the Lendore, Bullock now, Secretary, Attorney General, Trinidad and Tobago.
Apologies for keeping you waiting.
I will then go just make a few observations on chronology of what happened following Pratt and Morgan and how the sentences came to be closed, and then I'll come to my submission. The first point I made is this: the power of commutation is vested in the President, and it's for him to exercise, not the Constitutional Court, or indeed any court, save in a very simple case when everyone agrees what the answer is, like life imprisonment. Secondly, the Criminal Procedure Act does not vest in the judge any power to change the punishment which has been signified to him by the President. And further, there's no basis for modifying the Act in the 1976 Constitution. Third, I do with respect submit that it is not appropriate to consider on this appeal the question of whether life sentences or long sentences in Trinidad and Tobago are sufficiently reducible, whether one takes into account ECHR rules or otherwise. And there are 2 points I make on that. First, it's a point we run in our case, namely, the question is essentially academic. If the appeal is dismissed, this matter will go to the advisory committee and the President to reconsider all over again, without regard to the sentence and the punishment so far imposed. Likely. And conversely, if the appeal is allowed, it will follow that the matter will have to go to the High Court, or to the Criminal Court, to reconsider the sentences de novo. So you really are being asked to consider what is, in essence, an abstract question. And in any event, I say, the point that has now been run in this appeal wasn't run below at all. Totally different point was taken in relation to the prison rules. The consequence of that is you don't, there's been no evidence addressed to the sort of arguments my learned friend is running about whether there's a sufficient merits-based review, and you haven't got the views of the local court on that. And on such an important matter, one would have thought that is possibly the most important thing to have. Sentencing practice and so forth. We haven't got the local courts in it. But fourthly and finally, even if it is right to consider this point, whether fully or at least possibly partially, I say the punishments of life imprisonment or very long terms of imprisonment are sufficiently reducible, even if you transplant ECHR jurisprudence to Trinidad and Tobago. And therefore, my lords, I submit the proper course in this appeal is simply to dismiss the appeal and to allow the advisory committee to get on with consideration of the punishments as the Court of Appeal has suggested as soon as possible. My lords, as far as the preliminary points I wanted to make, it's important in my submission to bear in mind that no concern, blame or criticism can be levelled at the state for the punishments that were imposed on the appellants and others in 1994 and 1998. My lords, this is the chronology. On the 2nd of November 2003, Pratt and Morgan was decided. And if I can ask you to go to Pratt and Morgan, it's in bundle 4 of the authorities, because I'm going to come to this in a moment on another matter. Bundle 4, tab 42. You will see what the Privy Council, you have seen this before, but I want to emphasise it. You will see what the Privy Council recommends the Jamaican authorities do, and indeed a recommendation which was taken up, and understandably so, by all other authorities, as I understand it, around the Caribbean, in particular by Trinidad. And it begins at page 2467.
Yes, recommend commutation to life imprisonment.
Yes, I mean, they just so, my lords, and they say that's what everyone should do. Now,
where are we? Which page?
2467
at
G.
letter. Right.
So, when, for instance, in 1994, the President does just that, it is, in my submission, a bit rich to criticise him for passing what you might call a job lot sentence. He is doing what he believes should be done in the light of the guidance in Pratt and Morgan. My Lords, the same thing happened in Guerra, which was decided in 1996, I think, where in relation to, which was the Trinidadian case, where what the Privy Council did was, having decided that too much time had gone by, it again, of its own motion, just imposed the life imprisonment sentence, just like that. So I submit what my learned friend calls the job lot commutations in 1994 are entirely understandable. The state obviously took the view, that's what we've been told to do, and that's what we're now doing. In 1998, my Lords, you had the 75-year terms imposed, but I make the same observations in relation to those. It may have been thought that 75 years was somehow less than life imprisonment. My Lords, it's not entirely clear why 75 years was selected rather than life. But in any event, in my submission, bearing in mind what the current understanding was back in the 1990s, no criticism in my submission can be made of the state for passing those sentences. And indeed, it's noticeable that no one did make any criticism at the time. Now, as my learned friend indicated, the truth is that since the 1990s, there have been a considerable amount of developments in this area of the law, both in relation to who should be exercising the power of sentencing when it comes to life imprisonment or imposing tariffs, and indeed the appropriateness of life imprisonment where there are not sufficient safeguards to ensure that a man can get out before the end of his life. But, my Lords, one mustn't judge, in my submission, what happens in the late 1990s by reference to jurisprudence which took place in the 2000s and subsequently.
But if there have been considerable developments, that doesn't mean to say that what happened in the 1990s can continue to stand.
Oh, certainly not. That's not my point. But my point is this, that these sentences are going to go anyway, whatever happens. But one of my learned friends' criticisms is, well, look, you can't trust the state. Look how abominably they behaved in the 1990s. To which my answer is they were doing what most people thought was indeed entirely the right thing to do. May have been wrong. That's a different matter. But that's the point of my criticism. That's the point of the point I'm seeking to make. And likewise, my Lords, it's said, of course, that there was no review of the prisoners were not given the opportunity to make representations. All this happened out of the blue and so on and so forth. But of course, in those days, it was understood that they had no right to make representations.
What's the date of Lewis? Can you remind me?
Oh, yes. De Freitas and Benny's in 1974. That's so to speak, the locus classicus, or was the locus classicus. There was then a challenge to that in Reckley, which was from the Bahamas.
In?
Reckley,
Yep.
which was decided in 1996. And Reckley upholds De Freitas and Benny, no right to make representations and so on. I think Lewis comes along in 2001.
I thought it was about to.
So the only point I'm on, I'm not seeking to say these sentences now could be reimposed. I'm simply saying the state wasn't doing something outrageous in the 1990s. On the contrary, it was doing what no doubt was seen to be entirely conventional in the 1990s. My Lords, there's one other point I would like to draw to your attention in relation to these punishments that were imposed by the President. And this applies to all of them. If you go to Bundle 1 of the record, you can see in terms, let's go to page 138. This is an example of one of the life punishments.
Sorry, I...
138. 138. And you can see this appears to be a draft minute. Then sent to the President. And letter to the Chief Justice. One takes it from the advisory committee, as I understand it. And you'll see...
It's from the Minister of National Security,
Sorry, from the Minister-
by the look of it.
Yes.
You can pick that up halfway down 139.
Yes. And you'll see, my lords, it makes it plain that the reason for this commutation is Pratt and Morgan. And this is a standard form which applies to, as far as I can see, everyone who's involved in this appeal. One takes it, therefore, all the other people who've had their sentences commuted at the same time. So the first point I want to draw to your attention is the Pratt and Morgan point. This is expressly done on the basis of Pratt and Morgan. And the second point I want to make is on page 139. You'll see that para C, the prisoners affected by this decision, are in no way prevented from petitioning the Committee for Pardon. So it's not a sort of absolute final decision. And understandably enough, what appears to be going on is, well, we're commuting these sentences anyway. If you want more, come back. They never did.
Do you say that B, which is immediately above the bit you've just taken us to, on 139, was intended to, or did, add anything to a substitution of life imprisonment?
Well, the argument I think that was run by the appellants below was indeed it was an attempt to do so, therefore it was invalid and so on. To which
That's
the court
why I
said,
asked the question.
Yes. To which the court said, well,
yes.
whatever the intention, the effect is just a term of life imprisonment.
And you support that, do you?
Yes, my lord. I say that is the construction that should be given to it.
Thank you.
C is C viable? In other words, how could they petition? I see the petition of the committee for pardon, so for a complete pardon, I see.
Yes,
Or a conditional
or indeed conditional pardon, in my submission, and that
Something
makes
else,
sense.
yes.
This is all being done without your knowing about it. So if you want to come back and ask for more, I mean, I'm putting it colloquially, if you want to come back and ask for more, well, please do.
Right.
So that's why I say that my learned friend's suggestion there's a sort of a serious criticism to be levelled at the state by reason of what happened. I submit is misplaced.
The prison rules were presumably enforced at that time.
Oh,
weren't
yes, yes.
They must have been. They date from about 1940, 1950.
They do, yes. And my lords, I'll come on to how those prison rules were applied in practice.
Yes, I know. Yes, all right. Thank you.
In these cases.
Yes, I was just observing that there wasn't any reference to them, but
No, well, my lords, that's right.
we'll get
Not in the orders that were made.
no.
My lords, that's the preliminary point I wanted to make. Can I now deal with the question of the power of pardon? My lords, the starting point is section 87 to 89 of the Constitution. Tab in bundle 1. And, my lords, you've seen this before. The only point I particularly wanted to make in section 87.1 is that this is an entirely wide, unrestricted power. He can grant it either free or subject to lawful condition respecting any offences he may have committed, either before or after conviction.
Well, wait a minute.
Charge.
That 87.1 is actually only before conviction, isn't it? It's 87.2 that we're concerned with.
Yes.
But it's,
Yes.
but it's,
Forgive me.
it's equally wide.
Yes. 87.2c is the most.
Yeah.
My lords, I think, as I read 87.1, it may not matter. The first sentence is general,
Oh, I see.
and the second sentence is saying you can do it beforehand.
Well,
Maybe. Anyway.
Maybe.
It may not matter.
It may not matter. In any event, 2C is the important point.
I can't, yeah, I think the first sentence, it may not matter, but the second sentence is confining the first.
Yeah.
And, my lords, that power is obviously intended to mirror the power which traditionally had been exercised by the Crown on the advice of the Home Secretary in England until the abolition of the death penalty in 1965. And that, my lord, the reference for that, you'll be familiar with, is De Freitas and Benny, which you can find in volume 1 of the authorities at tab 15. My lords, I submit the wide words are significant, because historically, I'm not going to go to the authorities, you've seen what we say in our case, the power of pardon had been used in any type of case, including those where the condemned man had rights, if I can put it that way.
What, miscarriage of justice cases?
Yes, miscarriage of justice cases. It was in miscarriage of justice cases that, in fact, the power of pardon or free pardon was the only way of getting an acquittal, effectively.
This was before the system of Attorney General's references and...
Yes, in the 19th century.
Well, it's before before the Home Secretary had power to refer it to the Court of Appeal.
Yes.
And long before the CCRC.
Oh, yes, yes, yes.
I mean, that power came in, what, 69? Power to refer matters to the Court of Appeal.
Home Secretary? Yes, around then, I think.
Well, presumably...
And the CCRC is much later.
It was very relevant, presumably, before we had a criminal appeal system at all in the 19th century.
I think in 1848 you had the Crown Court Cases Reserved Act in which you could take a point of law, and if you happened to be on the right side of the point of law, then the court would, as I understand it, allow the conviction.
Yeah.
Then you had the 1907...
Yes, but the Crown Cases Reserved system was entirely different. That was a reference by the judge.
Yes.
And on very narrow grounds.
There was no right of appeal for a convicted defendant in England until 1907,
Yes.
which is the Criminal Appeal Act, creating the Court of Criminal Appeal, as it was then called. But I can't, I'm afraid, remember when the Home Secretary's power to refer...
I think it was the Administration of Justice Act 1969, but I probably misremembered that.
Yeah, could well be.
My lord, the history of this, you can see more of the history. There are two, well, there's a case called Foster, which is in the authorities at volume 4, at page 2492, in particular 2503 to 2506. That has a discussion of the history. And we've taken some extracts from Rolfe on the power of pardon, which you can see in volume 5, at tab 63, which goes into the history a little bit more. My lords, perhaps more pertinently, the power of pardon was also invoked and was the proper way of preventing execution of a sentence, even when you had a right to prevent the execution of the sentence. And my lords, the first point is Pratt and Morgan said, I mean, the decision of Pratt and Morgan was premised on there having been such a power in relation to delay in carrying out the execution of the death sentence. And my lords, that you can find in volume 4, tab 42, 2451. My lords, this was in essence base 2451.
2451.
And one can pick it up in the second paragraph at B. And this really is the ratio of the decision. It is difficult to envisage any circumstances in which in England a condemned man would have been kept in prison for years awaiting execution. If such a situation had been brought to the attention of the court, their lordships do not doubt that the judges would have stayed the execution to enable the prerogative of mercy to be exercised and the sentence commuted to one of life imprisonment. Prior to independence applying the English common law, judges in Jamaica would have had the like power to stay a long-delayed execution, as foreshadowed by Lord Diplock in Abbott. It's a reference to what Lord Diplock said. As was asserted by Lord Templeman in Bell, their lordships do not in any event accept the submission that prior to the Constitution, the law of Jamaica applying the common law of England was powerless to prevent a remedy against unreasonable delay. So this was essentially a matter of right. But you'd
Well,
still go to the...
it's a perhaps a mildly optimistic view of the common law's development. All right, there's certainly a power to stay to enable the prerogative of mercy to be exercised,
Yes,
but one puts oneself back into the 18th century or 17th century and asks, what if the prerogative hadn't been exercised? One wonders whether that wouldn't have been the end of the matter.
Not necessarily, because in Pitman, my lord, which is in the same bundle, 2431, which did indeed, there was a long consideration of the history of effectively the powers of pardon and what was the interrelationship between that and the court's powers. You can see...
As a matter of convention, one assumes that the prerogative of mercy would have been exercised, but it's probably right that at the time of the Constitution, it was not envisaged that exercises of prerogative powers were judicially reviewable. And indeed, there was a decision, I think, of the House of Lords, Lord Diplock giving the judgment, in which he says, obiter, that the prerogative of mercy is inherently unreviewable.
Yes. Yes, I would accept that. My point is more that the prerogative of mercy was still the thing that would be used to allow, in this case, a man who was under sentence of death to escape the sentence, in this case, on the basis of supervening insanity, let's say, between conviction and the time at which he would be sentenced.
Well, it's a matter of right, and I mean, you can't talk about something as being a matter of right unless you could enforce it in court, could you? And
well, you can get
if all the court could do would be stay pending the prerogative of mercy,
yes,
which
exactly.
it couldn't actually control, query whether that's right.
Well, my lords, it's very similar in that case
Maybe
to the situation
that
we have in this case.
bad history transforms itself into law.
I think, anyway, here we are.
It's certainly right that the prerogative is the origin of the developing practice over the 4 centuries before 1907 of not executing the insane and, indeed, and for that matter, the pregnant.
Yes, but it would be recognised even before the prerogative was exercised that what ought to happen is the court would make, effectively would say, well, this
Your point is
cannot be carried.
that where this was done, the juridical basis of it was the prerogative of mercy. And it doesn't actually matter much whether it would in practice have been controllable or not. That was how it was done, if at all.
Yes. My lords, I simply make this point in support of my submission. This was a very wide jurisdiction. It is not the case. What my learned friends, I don't know if he's abandoning the argument or not, but his argument came to this, the one in his written case, namely where a condemned man has a right to prevent an execution, it follows that the president's power is, so to speak, ousted. He just doesn't have it. Now, in his oral submissions, I think he went back on that submission.
But ultimately, it wasn't part of his case.
No, but if it is part of his case, I say it's wrong. For the avoidance of any doubt, I say it must be wrong. My lords, the one which my learned friend developed was, of course, effectively that the Constitutional Court has a parallel, indeed superior jurisdiction to the President. My lords, I submit that cannot be right. One starts with Section 14 of the Constitution, which is the only source, I would submit, for this power. Volume 1. And my lords, the important points, or the important words, rather, are the tail-end words, and may, subject to subsection 3, make such orders, issue such writs, and give such directions as it considers appropriate, for the purpose of enforcing or securing the enforcement of any of the provisions of this chapter to the protection of which the person is entitled. Now, my lords, clearly, a condemned man is entitled to ask for the court's intervention if he's about to be executed, when it would be inhuman to execute him. And that would be effectively a right to stop execution, and that is the redress. That's the redress he needs in order to preserve his constitutional rights. No doubt, my lords, perhaps also, if it were the case, I'll come to the point in more detail in a moment, if it were the case that, let us say, that has been some, as a result of the prolonged detention when he shouldn't have been detained, there has indeed been cruel and unusual punishment, then of course he could no doubt ask the court for constitutional redress in the way of damages, as happened in one of the cases. My Lords, I submit it certainly doesn't follow from that the condemned man can also go on to say to the Constitutional Court, once he's got his stay, and by the way, I want you now to determine my sentence, not the President. One asks rhetorically, well, what constitutional right is it that's being protected if the court were to award that order as well? Bearing in mind...
Do you say the Constitutional Court hasn't... it's not the Constitutional Court, is it? It's the High Court on a constitutional motion.
Yes.
Do you say that the High Court on a constitutional motion under Section 14 of the Constitution, assuming there has been no exercise of the pardon,
Yes.
Is not entitled, in saying, thou shalt not be executed, to add, and you shall have X sentence of imprisonment in substitution?
If it's common ground, or if it's, for instance, as in Pratt and Morgan, if there's only one thing that's, as we're in consideration, if it's common ground, there's one thing that's been done, then I submit, of course, the court can do it. But, my Lord, if there is a debate, and let's say the condemned man says, well, I want the court to exercise this power, and the state says, no, this should go to the President, in my submission, the appropriate course would invariably be for the court to say, well, the President should exercise this power, the power of commutation.
Then you're discussing a matter of discretion.
Well,
can
yes.
we just test Lord Hughes's question? What if the President hasn't commuted?
Yes.
Is the position, and you can ask the opposite or answer the opposite. What if the President has commuted?
Yes.
I think I can foresee the answer there, but what about the former? If there's simply been no commutation...
Is there power, is the question.
Well, my Lord, I would accept there's a power, but not...
Where would the power come from? What's its juridical basis?
If, for instance, the President had stubbornly refused to exercise any power of pardon...
That would be by way of review of his stubborn refusal.
Yes, but it might be said you've been deprived of protection.
Well, quite. But, I mean, I can quite see that the court might have a power, and so the President's failure to exercise his powers in circumstances where he was bound to do so, or where he'd exercised them in an unsatisfactory, reviewable way. But what happens if that route is not taken? Do you submit that the absence of a statutory power and the lawfulness of the original sentence have the combined effect of depriving the Court of Appeal of any right to re-sentence themselves?
Well, my Lord, they would not be remedying any constitutional breach.
Yes, they would, wouldn't they? Would. For a start, it wouldn't be the Court of Appeal, of course, it would be the High Court,
yes.
But that's irrelevant. But why wouldn't they? When a man who has been convicted of murder, there's a substantive conviction which remains, there's no question of that disappearing. When he comes to the High Court and says, I'm about to be executed in breach of my constitutional rights, why on earth can't the High Court say under Section 14, we agree you can't be executed, you remain a convicted murderer, and you must serve the appropriate sentence?
Well, my Lord, the short answer to that is the power of commutation is vested in the President by the Constitution itself.
A power of commutation is vested in the President, yes.
And sentencing in such event.
All right. Well, I mean, you may be right, but it's certainly not what Lord Griffiths had in mind in Pratt and Morgan, is it?
Well, in
mind that there could be constitutional motions by all these people, and that the exercise of the prerogative of mercy was an alternative route to achieving constitutional compliance.
Well, my Lords, of course, there had already been, one presupposes for the moment, a breach, and therefore they'd be entitled to bring a constitutional motion for an order restraining the carrying out of the sentence, certainly.
But it would be confined to that.
Yes. My Lords, the way I put it is, imagine a very simple case where the President hasn't done anything wrong, but he just hasn't exercised his power of pardon, and the condemned man comes to the court and says, please, A, give me a declaration that it would be unlawful to execute me now. Please,
ask for an order directed to the governor of the prison not to carry out
exactly
the sentence, thereby making the sentence unenforceable, but it would continue in existence in a formal sense unless and until the President commutes it, thereby bringing the original sentence to an end and substituting something different.
Yes.
Is that your analysis of the position?
Yes. Yeah.
But is that not supported by, in section 14(1), the fact that the power given to the High Court is without prejudice to any other action with respect to the same matter which is lawfully available?
Yes.
So the High Court, insofar as the Constitution does provide another mechanism, the power under section 14 doesn't impinge upon it.
No, exactly. My lords, I accept in certain circumstances, you can imagine an extreme case in which the court would say, to give effect to your constitutional rights, bearing in mind the way the President has behaved, I'm going to order the court does this. But absent that, if the President has done nothing wrong, then in my submission, the proper, and indeed the only proper answer is for the court to say, well, I'll stop the execution and I'll remit the matter to the President to consider the power of pardon.
So the contrary assumption, and it was probably only an assumption, in Hunt and Khan was in fact erroneous.
Well, yes, it was. The trouble with Hunt and Khan is it proceeded on the premise that the Privy Council itself had jurisdiction.
It was undoing the proposition that the Privy Council itself had jurisdiction in the absence of any constitutional motion, simply on an appeal against sentence.
Yes.
And that it doesn't present any trouble.
No.
But you say that the assumption, which is pretty clear in that judgment, that it could be done by the High Court in Trinidad, was it?
I think it was Trinidad.
Yes, anyway, the local High Court on constitutional motion was in fact erroneous.
Well, it may have been erroneous, but consented to.
Didn't matter.
I
No, it didn't
no
matter.
one took the point.
No, okay.
My lords, whether it's a matter of jurisdiction or a matter of propriety, my lords, I don't want to get too bogged down in the difference between jurisdiction and propriety, but I submit, unless the President has done something wrong, then the proper response for the court is to say, I will send the matter off to the President, because this is his power, not the court's power to exercise.
Isn't there authority that provisions like Section 14 are of a residual character?
Yes, my lord, we refer to in our case, Giroux is my lord, there are plenty.
They're only residual. I mean, there's also authority that they are, to use, I think, Chief Justice, was it quoted by Lord Bingham, Byron, or Sir Dennis Byron's, unlimited. But Lord Bingham himself thought it a very wide power. And I wonder whether, without prejudice to any other act with respect to the same matter, which is lawfully available, was really intended or contemplated as covering a right to seek the exercise of somebody else's discretion. I mean, where you have, what it really focuses on is the obligation to exercise other other remedies where available, e.g. common law remedies. You don't assert grand constitutional remedies if you've got a perfectly straightforward claim for breach of the prison rules or something like that, or common law duty of care. But was it really directed to the present situation?
Well,
and should we upset the assumptions? There are Court of Appeal decisions in the Caribbean to the effect that Section 14 or its equivalent gives the power to a High Court to re-sentence, aren't they? They're quoted by Mr. Fitzgerald.
Well, it has happened, my lords. I think part of the problem is this issue has never arisen before. So sometimes it's just gone by default that it's been accepted.
Surprisingly, since Pratt and Morgan indicated, as my lord said very clearly, that this was something that was within the power of the High Court.
But the difference with Pratt and Morgan and here is Pratt and Morgan, there was simply no argument about it. It was life imprisonment. That was assumed to be the only thing that could be done. The difficulty that arises subsequently, people have taken the point, well, hang on, I can get something better than life imprisonment. And the question then is, well, who decides that question? Because if there's only one answer, well, of course the Constitutional Court, the court can do it. There's no point, so to speak, sending to the President that which everyone knows is the only answer on offer.
I mean, just testing that proposition, let us suppose that for some reason there is a delay. The President responds, the prisoner goes to court, there is an injunction saying or a declaration saying he can't be executed. But there then arises the question whether his detention pending execution is lawful, bearing in mind that he can't be executed. Now, I think the logic of your submission is that the prisoner's next step, if the President doesn't get a move on and commute it and substitute something else, is a writ of habeas corpus.
Yes.
I can't be detained any longer unless and until the President
Does something.
commutes the sentence and substitutes something different, which he hasn't done.
Yes. I mean, no doubt, my Lord, the court would preempt that.
Well,
By saying, well, look...
these are all rather remote possibilities in practice, but they are quite useful to test the coherence of the legal submission.
Yes, well, in my submission, that is exactly what would happen. Or more realistically, what would happen is the court would grant a stay of execution and say, pending determination by the President, then you shall remain in prison. As part of the constitutional remedy, pending determination by the President, you shall remain until the President decides what sentence should be imposed instead.
I'm not sure for my part that this is a problem, because it seems to me that the natural implication in a situation where no one is acted is not that you are entitled to be released or they've been convicted of murder and sentenced to death, which can no longer be executed. It is that pending something, you are going to be held. It's not pending execution, and it is pending either the commutation by the President or the commutation by the High Court. So it doesn't help us answer which has power to do that.
Somebody would have to decide that. An order to that effect would need to be made.
Well,
presumably
somebody's
by the High
got to
Court.
decide it, and presumably
The High Court.
there must be some onus on the prisoner himself if he's not satisfied with simply being pending and wants to resolve what his position is in terms of years of imprisonment, an onus to take one course or the other. If the President won't act, then the alternative would be the High Court.
Exactly. My Lord, my Lord, that much I would accept. If the President simply does nothing, you then need to enforce your rights, you then need to get the court involved. But if the President is prepared to be involved, you don't need to get the court involved in order to protect your human rights.
But the question is whether, if the court does get involved for that reason, the President has done nothing, does the court re-sentence the person himself, or does the court effectively direct the exercise of the Section 87 power?
In my submission, the latter, unless the President has so misbehaved. But let us say he's already done nothing twice. There might come a point at which the court will say, well, look, we're going to have to take this function over because he doesn't seem to be prepared to do it within a reasonable time. And you are at least entitled to that within a reasonable time. And so to protect your rights to having what you like.
That the President not acting in accordance with the direction of the court, that he must commute it and substitute another sentence.
Well,
What's quite important is whether the kind of direction that the court can give is there must be an exercise of the Section 87 power of commutation and a substitute sentence, or whether it can go on to say what the substituted sentence ought to be.
well, my Lord.
And you are saying, as I understand it, that the court either cannot, or even if it can, should not, exercise any power to substitute a sentence. It must be left to the President. Now, I hesitate to ask, but since you've raised a point in relation to some of Mr. Fitzgerald's submissions, is this a question which was ever raised below?
Off the top of my head, I don't know.
Well, I suspect it wasn't.
But my Lord, what I do say is, well, I'm not sure the argument quite went like this below. I think the argument was there was simply no power vested in the
Yes, I
President.
think that's probably right. Quite important, because we haven't on this either any view about current practice. We simply don't know, do you, how many of these people actually do launch constitutional motions and have sentences substituted by the High Court? Some may.
Well, my Lord, there appear to be 2 points. If I can make this point, I accept that if there's only one answer, if there is thought to be only one answer, then the court can do it, because the court is simply doing that which the President is bound to do anyway. So I accept, because that's what happened in Pratt and Morgan, and indeed in many other cases.
What's the juridical basis of that? If the only power is vested in the President, it's hard to see how the court can simply say, well, the President is bound to do this, so he won't do it, we will instead.
Well, to speed things up, I suppose, might be said if the answer's obvious.
Juridical principle.
Well,
Certainly done it in other contexts, I mean, very, very distant contexts, where... right, are you suggesting that the court could actually order the President to exercise his powers and the advisory committee in a certain way? I mean, the difficulty I have is if we are postulating, I think, a pretty unreal situation.
Yes.
But what would happen in that situation?
well, my lords, in the first instance, the court would simply say this is a matter, as has happened here, this matter will be remitted to the President for him to consider. My lords, you added it in a certain way. My lords, I would submit it's unlikely that the court would have a power to direct the President positively what sentence he should come up with. My lords, I would submit that's not within the court's power. No. That's for the President.
But if it has the power to substitute a sentence itself, which seems to have been assumed until you were on your feet this morning,
Yes.
then it will simply do that, and the occasion for the exercise of the President's Section 87 power will not arise.
Yes, but my lords, you have my caveat on
Yes.
that. That's when there's only one thing that can be done, or at least there's simply no debate on it.
But arguably there's even more of a case for it being undertaken by the court as an exercise if the answer isn't obvious than if there's only one option.
If, my lords, if you had a differently structured constitution, my lord, that would no doubt be right.
Yes.
My lord, as you can imagine, my whole submission in this case is Mr. Fitzgerald talks about the separation of powers, but the real problem for him is the separation of powers is in the wrong dividing line.
We've got that.
In this case. Well,
Isn't the solution to a lot of these problems, if you're concerned about the court usurping powers of the executive or the President, that it was up to the President to get on with it and to look at these people's fate and to actually substitute another sentence. If the President hasn't done that, and A for sure, if he's not willing or she's not willing to do it, why isn't Section 14 wide enough? Just to give you an example from a very different sphere, there are two authorities of the Privy Council which say that if the executive doesn't get on with the business of issuing broadcasting licenses,
yes.
then the court will simply order the issue of a broadcasting license. We've done that on two occasions where people were being deprived of their broadcasting license.
Simply ordered the issue of the license by the relevant authority.
Well, we ordered in one case, I had a look at them, but in one case we just made an order against the state.
Yes, I think I was in it.
In the other case, I think we ordered the Attorney General to procure it. But, I mean, that was under Section 14.
Yes.
It's a very broad power.
Well, my lords, I don't make the submission that even if the President's done absolutely nothing, when he ought to have done something, the court can't step in.
Well, it
it
may
might
be
be said, by virtue of that, the President himself is, by virtue of the President's continued delay in doing anything, he is what you might call prejudicing the rights of the appellant, and so to enforce his rights, to protect it, to give his rights proper protection, the court then does do something about it.
Sorry? That you are on the footing that the President would be acting unconstitutionally
Yes.
in failing to do it, so that it then becomes necessary, in order to give effect to his constitutional right, to make an order under Section 14 that wouldn't have been appropriate at an earlier stage when the President wasn't apparently being recalcitrant.
Yes. And my lords, what I wanted to emphasise was right at the end, for the purpose of, it's for the purpose of enforcing or securing the enforcement of the provisions. And so the remedy has to be for that purpose. You can't just say, well, I've got a remedy, I'm entitled to remedy 1, and on the back, which undoubtedly I do need for the purpose of protecting my rights, but on the back of that remedy, I'm also entitled to remedy 2, which actually I don't need the court to exercise to preserve my rights.
But there isn't really a sort of overlap of the two. If the President does get on with it, exercise the power of commutation, that will remove the death sentence, and there's no basis on which you go to court, I think, I imagine your submission. We put this to Mr. Fitzgerald.
Because Mr. Fitzgerald, what you might call his extreme position was, well, it doesn't really matter.
Yes, but the alternative, or the other view, is that the basis simply falls away on which you would go to court.
Yes.
Unless you're criticising the President's decision as to what sentence to substitute.
Absolutely. Then that's a different,
It's a different kind of
different exercise involved.
Right.
But my Lords, my primary submission is, imagine a man who nothing's happened to him. He goes there after 6 years. He says to the court, restrain the execution. The court says, fine. Everyone agrees on that. And then he says, I want the court now to carry out the sentencing exercise. And the Attorney General says, no, that should go to the President. And that's the question in the case. What should happen in what you might call the normal case? And in my submission, in the normal case, the court should say, well, this power is vested in the President. I shall remit the matter.
Hasn't refused to do it. Therefore, there's no necessity for the purpose of Section 14, not yet anyway.
Yes, exactly.
Yes, I wonder if it technically might not remit, but would it perhaps stay the proceedings so that if a reasonable time elapsed and nothing had happened, a further application, or allow, or perhaps simply reserve the possibility of a further application being made in the event that nothing happened?
Yes, for my Lords, exactly. That is what could happen in the sort of case I've mentioned. But prima facie, the court should say, this is the President's power, I shall send it off to him to deal with. Unless you can persuade me, you come back later if he still hasn't done anything, and we'll reconsider, and so on.
It was dealt with by Raja Kumar at page 631. He deals with this express point.
Oh, my Lords, I'm told, yes, I'll come to that. But my Lords, that in my submission is the answer to Mr. Fitzgerald's point. It's always for the President, unless there's some need to involve the court, but it has to be a need to involve
You will at some point come to the more basic point, whether it is really a very happy situation that so much rests on what is ultimately executive power. And maybe that's a consequence of the enshrinement in the Constitution of the presidential power of pardon, but I can't believe that power of pardon was directed to this sort of situation, even though it covers it. There is something slightly unsatisfactory, isn't there, as Mr. Fitzgerald submits, in a situation where the executive has allowed proceedings, or perhaps the court system has allowed the death penalty to hang over someone's head for longer than the permitted time, so that you need effectively to have a resentencing, but it's not done by the court.
Well, my Lords, one might say that as if one was writing the Constitution from scratch, you might well say that. But my Lords, you have my answer. Whether it's satisfactory or not, I submit that if the power is vested in the President in the first instance, it's for the President. My Lords, I do also submit this. You do not have evidence before you that the power of pardon is exercised irresponsibly.
Indeed, we have evidence to the opposite effect, because we can see what has been done in these relatively numerous cases.
My Lords, one might abstractly say, I can see there are all sorts of risks involved in this, which, were the matter decided by the judge in open court, wouldn't exist. But in my submission, that is not a sufficient reason for departing from what I submit is the clear intention of the Constitution.
No, well, we do have evidence, of course, of what happened historically, and you've answered that point by saying things have changed. There will be a question if we go down this line as to how far we actually indicate clearly how much they have changed for the purposes of cases like this.
Yes. My Lords, can I just come to another problem which my learned friend's case gives rise to, is if the President has exercised his power, and let's say there's nothing particularly excessive in the sentence or irrational in what he's done, my learned friend's case comes to this. He can still ask the court, and that will be backed up by a court order from the Chief Justice. So,
No, I think we've got this point. Your point is basically that it's a very odd situation if you have a complete de novo review of something which has been converted into a court order.
Well, and a risk of inconsistent orders.
well, indeed. I mean,
I mean, what you do with the previous court order and so on.
The difficulty with my learned friend's submissions, indeed the point you put, my Lord, is that the logic of it is precisely Mr. Fitzgerald's position. Because otherwise, it comes down to what you might call a race.
Yeah.
If the President gets in there first, oh, bad luck. Whereas if the President doesn't get in there first, you get a court and think, thank God I got in there.
But it's not a very effective race because the President is presumably likely to be a good deal quicker than the court in exercising any power.
I don't know, my Lord.
Well,
it all depends. I mean, there are some litigants who are very quick off the mark and who My lords,
Well, the whole
rational.
lesson of these cases is that court systems are not always quick.
No, well, obviously. But my lords, I do submit it is an important point. The logic, and that's why in my submission Mr. Fitzgerald has to make his submission, because to the effect that there are two concurrent jurisdictions, because he recognises that otherwise the answer is it depends who gets in there first. And that can't be, as it were, the intention of the Constitution. And that's, I submit, the answer to my lord, the point you put to me. That's why, as a matter of what you might call legal logic, my learned friend's position cannot be right.
But I don't think, in fairness to Mr. Fitzgerald, it is a question in his submission of who gets in first. What he says is that if the individual wishes to exercise what he says is his constitutional right, that cannot be ousted by the president. So
Yes.
there are concurrent jurisdictions, but it doesn't depend on which is invoked first.
Oh, I agree. I mean, his submission is indeed just that, but I submit he has to make that submission, because otherwise he's left with saying it depends on who gets in first. So and I submit that is the difficulty his submission faces. It's either the extreme submission, or it's a matter of who gets in first. And my lord, can I just mention one other oddity which results from my learned friend's position? Imagine you've got a man who's been on death row for just 3 years. He doesn't have a Pratt & Morgan point at all. Assume for the moment he doesn't begin to have a Pratt & Morgan point. And then you've got another man who's been there for 6 years, who's got a cast iron Pratt & Morgan point. Now, there's no doubt, and let's say the offences were very similar, but the man who's been in there for 3 years is a very deserving case indeed. Now, in his case, the only remedy he has is to go to the advisory committee and the president say, look, I'm an incredibly deserving case. I was a national hero, whatever it is. I'm a very, very deserving case indeed. Please commute my sentence. The president says, certainly, and then he imposes, as he has to, a sentence. There's no question of that man having any right to go to the Constitutional Court, even though he's a very deserving man. Whereas the 6-year-old man...
Well, I don't understand why this is a forceful point.
Well, my lord, because he has, apparently, according to my learned friend, he does have a right to ask the court to impose the sentence in lieu. Why should, in other words...
He being the 6-year man.
Yes. According to Mr. Fitzgerald.
That's because there's been a constitutional breach, which there hasn't been in the case of the hero.
That is true. That, my lord, is true. But as far as the actual passing of sentence is concerned, what difference does it make that there's been as far as that question is concerned, why should the constitutional breach...
It's normally the function of courts to correct constitutional breaches.
Exactly.
The point that you're making is that it would be odd if there was a difference between the consequences of a presidential commutation, depending on whether he whether he chose to do it or had to do it.
And you can certainly say that Section 70 treats the 3-year case and the 6-year case identically, but of course not for the purposes of a constitutional remedy, but for the purposes of the consequential court order following the pardon. Yeah.
Well, I take your lordship's point. Of course, there's been a constitutional breach in the second case, but the constitutional breach doesn't really explain why the court gets involved in the sentencing process. In his case, as opposed to the man who's a very deserving chap indeed, who's been in there for 3 years. Right, anyway, that's the point. My lords, I don't know if there's much more I can say on this. There's no authority on the point that I'm aware of. Other than to say, well, just look at the Constitution and the purpose of Section 14. My lord, we refer to the...
If you can give us throw any light on the extent to which this point was touched on at all below, that might be interesting.
Justice Raj Kumar, on the question of remedy, page 631 to 633.
631, 633.
My lords, the Court of Appeal comes to the
That's rather... He's dealing with the possibility that the computations were unconstitutional.
Yes.
So the premise is that there were commutations
Yes.
by the President. So he's within that system. It's not surprising he wasn't prepared to quash the commutations, in which case he would have stepped back into the position that you've been discussing. But he didn't say, he said he wouldn't do that. He'd just remit the matter to the advisory committee and the President.
Well, I'll come to the Court of Appeal's judgment in a moment, because they too consider this question of, obviously, of what to do. But can I come to that in a moment?
But they say roughly the same, don't they?
Yes. Yeah. My Lords, my learned friend relied on the case of Cord. If I can just briefly make a few submissions on that. That was a very different case. If I can just say what the point was.
Where is it?
It was a case from Grenada. It's in Bundle 6, Tab 6 of the, Bundle 6 of the authorities, Tab 3. And my Lords, one can pick it up at the beginning, paragraph 6 and 7, which explains essentially the history. This was an historic conviction and sentencing to death under what was then thought to be the lawful mandatory death penalty regime back in 1991. And then, shortly after that in 1991, his sentence is commuted. You get that from paragraph 8. So that's the background, an historic conviction and sentence under the mandatory death penalty regime, and then a commutation by the Governor-General. Effectively, life imprisonment with hard labour. In 2002, I think, you get this from paragraph 9, the Privy Council holds that the mandatory death penalty was unconstitutional. And so the appellant says, well, hang on, it follows that the sentence that was imposed upon me back in 1991 was also unconstitutional. Therefore, I want A, that sentence set aside, and also B, the dependent commutation by the President set aside as well. And that's his argument, to which the state says in response, you get this in paragraph 27, essentially, this is all water under the bridge. It took place ages ago. It's raised judicata. And that part of the argument, I think my learned friend did take you to, which begins at paragraph 26 onwards. My learned friend took you to this yesterday. And, of course, the board said, well, we don't much like the idea of raised judicata in a death sentence case. And he's entitled to have his sentence set aside because it was unlawfully imposed. As he's entitled to have his sentence set aside, the question arises, well, what should happen? And they say, well, it's obviously unsatisfactory. He does have an advantage in having his sentence set aside, and therefore the commutation set aside, because it's better to have your, what you might call, sentence imposed by the court rather than by the President. But all that's on the basis that the sentence itself was an unlawful sentence from the very beginning.
So there has never been a sentencing by the court.
Yes. And he was entitled to a sentencing by the court. That's the crucial point. Although no one realised it back in 1991, he was entitled to a sentencing from the court. It follows that he should now be entitled to a sentence by the court. And that, in my submission, is a good example of exactly where it is necessary to give effect to someone's constitutional rights. Because that was what he was always entitled to, and he never had it. So it should be for the court and not the President. But that's not our case here. Because the appellant doesn't have. The appellants don't have the right to have the sentences set aside. If they did, my lords, this would be a completely different case. I accept that. But that's the difference between this case and Cord. My Lords, can I now just deal with the Court of Appeal's order? Because this is really the substance of my learned friend's attack. He says the Court of Appeal has made the wrong order. And it's in Bundle 3. And they deal with this point in 2 paragraphs. The first is in paragraph 101, 783.
Sorry, 7?
783.
783, thank you.
Paragraph 181 is the first passage where they deal with the question of what to do, having found that there was a breach of the fairness provisions by the President or the Advisory Committee. Can I just ask you to read 101 to yourself, and then paragraph 116 on page 789. And my Lords, you can see there the Court takes the view that it might have had a jurisdiction to do this, but it's not appropriate to exercise a jurisdiction when the primary decision maker can still make it. And in my submission, this decision by the Court of Appeal to remit the matter to the President was right, really, for the reasons I've already mentioned before. He's the primary decision maker. There's no question of any flagrant abuse by the President.
So the jurisdiction here would arise on the basis that the President's and or advisory committee's power had been improperly exercised.
Yes.
And therefore, under Section 14, the Court potentially has a right to intervene, but perhaps in the light of the, without prejudice to any other action with respect to the same matter which is lawfully available, perhaps in the light of general principle, the proper course is to send it back to the primary original decision maker.
Exactly. It's not necessary for the Court to protect this man's rights. It's not necessary for the Court to get involved. We can send it back to the primary decision.
So, I mean, you would say on any view that is this case,
Yes.
That is good law.
Yes.
And we wouldn't actually need to go into the more fundamental question, what would happen if neither had acted?
Yes. Well, my Lords, the point's been raised, but in my submission, I submit this much is correct, even assuming some residual jurisdiction.
Whatever the answer on any other situation.
On the basis, as I understand it, that if the defect that you have uncovered is a procedural defect before the advisory committee, the appropriate remedy under Section 14, however wide it may be potentially, is to cure the defect.
Exactly. And my Lords, that's why I started off by saying this is not a case of flagrant abuse. I mean, clearly you might say that the President's behaved disgracefully, or you can't trust the man. Well, or you can't trust the system at all. There may be a different answer, but that's not this case. This was the failure to follow what you might call the guidelines in Lewis couldn't have been more innocent. And they were simply following the law as then understood. This was pre-Lewis. My Lords, can I just make a point about Lewis? My learned friend says, well, the protection given by Lewis isn't really all that great. My Lords, that in my submission is not correct. My Lords, we have Lewis in Bundle 3. I don't think we have in the appeal cases reports, but I don't think that matters. It's Bundle 3, page 1879. And, my lords, one of the questions in this case was, what rights did the condemned men have to make representations to the advisory committee?
Yes, it's 2001 two appeal cases.
Yes.
I think,
And, my lords, I think, in fact, I said it was decided in
page
2001.
50, yes.
Yes. It's decided in September 2000, not 2001. But the important point in this case, you can find at 1902, perhaps one can pick it up actually at 1901, because one of the arguments was that, advanced by the government, was that the condemned men, all they needed to know was to have some sort of idea of the gist of the material that was made available to the advisory committee. And you can pick that up on page 1901, 1901G. And the Privy Council wasn't having any of that.
That means all the material put before the
Yes.
advisory committee, not just, I mean, the paragraph starts by talking about international human rights
Yes.
bodies, but it's not confined to that.
No.
No.
And then over the page, 1902, after the recitation from ex parte Doody, you'll see D, their lordships have so far dealt with the matter on the basis there's a right to put in representations. And then it says this, these should normally be in writing unless the Jamaican Privy Council adopts practice of oral hearing. The lordships are not satisfied that there was any need for or right to an oral hearing in any of the present cases. So the point is not, they're not ruling it out. They're just saying on the facts of this case. The more important...
Presumably be an obligation in every case to consider whether there should be an oral.
Yes, yes. So, in my submission, it's not the case that you haven't got the sort of ability to make representations before the advisory committee which you have before a court, or indeed to ask for reasons, if that's what is regarded as fair.
Well, would you accept that there ought to be reasons given?
Well, as a matter of general principle in the Ministry of Law, that is what is required. Certainly if they're asked for, so that you know whether there's been an error.
Yes.
So, my lord, in answer to my Lord Mance's point to me earlier, it might all seem a bit odd that surely it's better going off to court. Well, the difference isn't as great as my learned friend suggests, or may have suggested. My learned friend also says, effectively, the condemned man is being judged by his enemies. There's the Minister of National Security and the DPP and the Attorney General. In my respectful submission, one mustn't underplay the importance. These are men in offices of state and highly responsible positions. And one shouldn't start from the premise that they're going to have it in for the condemned man. Or indeed take into account illegitimately what you might call entirely political considerations.
They're also required by the Constitution to be on the advisory committee, aren't they?
Yes, they are. Well, they are, my lord, exactly, but one cannot assume that they are. I think the suggestion being made...
Even if one could assume it, I mean, it may be that the presence of bias would lead to applications for judicial review or possibly constitutional motions on particular facts.
On the particular facts.
But the mere presence of a person who might be thought to have an interest in life difficult for a prisoner can't possibly be unlawful if the Constitution requires it.
Yes.
The mere presence.
So, my lords, exactly. So, my lords, I submit this is not what you might call a fatally flawed system, which I think was, or a flawed system.
Well, if it's a flawed system, the Constitution requires it, and there's an end of the matter.
Exactly. That's my second point. It's not, in fact, a flawed system. Lords, I think that deals with what I wanted to say in relation to the power of pardon taken on its own. The next question is Section 70 of the Criminal Procedure Act. And my lords, we have that in Volume 1, Tab 2. My lords, in fact, it might be helpful just to see in context. We do have the whole body of the Criminal Procedure Act, because what is missing in the citation here is Section 69, which is also dealing with the power of pardon. So perhaps one ought to see.
Where do we go for that?
My learned friend Mr. Atwell has got, I think, some copies.
Thank you.
My lords, this Act was passed in 1925, a point I'll come back to, which I imagine is the reason why you see in Section 69(1) the reference to the effect of a power of pardon. Section 69. And then Section 69(2). It doesn't add much. And then Section 70 is what you have. Now, in my submission, my lords, you've seen Section 70 before. I submit the purpose of Section 70 is simply to provide for the court to record the President's order. So there is, from that point onwards, a court order which records the position. That's what it's trying to do. And you get that from the final words, the last 6 lines down, and such allowance and order shall be considered as an allowance and order made by the court. That, in my submission, is what is going on here.
So the primary section is Section 69(1).
Yes.
That's what it all happens
Yes.
under, and 70 is simply, yeah.
It's sort of filling in the procedure. What happens once this has happened? So, and my lords, that makes sense, because, of course, you do want what you might call a pardon. You do want a court order, so to speak, to counter the previous court order. And that is all that's intended. And I submit it's very difficult to get what Mr. Fitzgerald wants into it. Effectively, his submission comes to this. The Chief Justice doesn't have to, well, he might have to take notice of what the President says, but he can divert from it. And as put to him yesterday, he can say, well, I think that's a ridiculously low sentence, I'm going to bump it up. Or he can bump it down. Well, my lords, there's nothing in the words that suggests that.
They're both actually procedural, aren't they? I
Yes.
mean, the first one is saying this is what the effect is.
Yes.
And the second one is saying, well, this is how you record it formally.
Yes.
But the primary, the actual power
Yes.
is
The President.
constitutional's power.
I think 69(1) is a little more than procedural. It says that the effect on the offender shall be.
Yes. Yes, it provides for other purposes.
Yes. Yes,
But my lords, the short point is this is a procedural statute. And you get that right. It is obvious as you go through it. This is to deal with things like evidence, arraignment of insane persons. All you have to do is look at the index to see what the statute deals with. And its preamble says an act to regulate the procedure in criminal cases, trial, and indictment. So it's an entirely procedural act, and I submit for that reason alone it's very unlikely to have been intended to effectively give the Chief Justice a jurisdiction in those days to depart from what the Governor-General would have said. And, my lords, I say in those days because that's 1925. And, my lords, I don't think there's any suggestion anywhere, when one looks at the 1953 report into capital punishment, there's no suggestion anywhere that any judge has ever had a power, so to speak, to second-guess the Home Secretary or the Governor-General and say, well, I think you've got the wrong, I think you've commuted too high or too low, and I'm going to impose a different punishment on commutation. And that was unheard of, my lords, as far as I'm aware, throughout the common law world.
Actually, it would be a new power outside the scope of the Constitution, wouldn't it? It'd be I mean, I suppose you would call it a judicial power, but it's certainly not one which is envisaged in the Constitution.
Well, certainly not one envisaged in the 1962 or the 1976 Constitution, but in my submission, not one envisaged back in 1925 either, when this statute was passed. And one has to ask, what was the frame of when this statute was passed, what did the draftsman think he was doing?
Yes, quite. Yes.
And he couldn't have been thinking about granting the Chief Justice a power, especially when you look at the rest of the provisions, a purely procedural act. Yeah. So, in my submission, that's the short answer to the point, and that's also the answer to the modification point. My learned friend says, well, the Constitution Act, which introduces the Constitution in Section 5, gives the power to the court to modify a statute in order to bring it in line with the Constitution. I accept that. But the difficulty is, if you read the Act as I submit it should be, naturally, there's no inconsistency. All the Act is saying is that the Chief Justice must put into legal effect, or turn into a court order, the President's pardon. There's nothing unconstitutional in that at all. And I would go, with respect, put the point the other way round, to suggest that the purpose of this Act is actually to give the judge the power to alter what the President has said, itself would be in conflict with the Constitution. The Constitution plainly proceeds on the premise that the President's order is going to be what matters, not some later order by a judge who's recording his order. So I submit there's no conceivable basis for modification.
Right.
My lords, that deals with the criminal procedure point, and I think it brings me on to the question of whether these sentences, or whether sentences like those that were passed, or punishments that were imposed by the President, were cruel and unusual by virtue of their length and irreducibility. My lords, I've flagged up the 2 points I want to make, and can I just repeat them briefly? First is, this time with references, I've made the point, this is essentially an academic debate at this stage, for the reasons I've given. Whoever wins, they're going to be reconsidered, these sentences. The second point, my lords, is that
Yes, but they are. But if they were, as Mr. Fitzgerald suggests, to be categorised as cruel and unusual punishment, we perhaps ought to say so, ought we?
Not quite sure, my lords, that was the basis on which this case has been put, that the sentences themselves were cruel and unusual punishment. I stand to be corrected if that's...
I think it is suggested that the substitute sentence...
Substitute?
Yes.
Cruel and unusual.
Yes, it is,
Yes,
because they're insufficiently reducible, because of the powers of review, etc., etc.
Yes. My lords, I agree, the general point was raised, but it wasn't suggested that these sentences were cruel and unusual because of the irreducibility on the grounds now being raised by Mr. Fitzgerald. That's the point I'm going to come to in a moment.
Oh, no, it's new here. Yes.
But, my lords, yes, I can see the point. If, in fact, these sentences were cruel and unusual, my lords, it might be said there should be some declaration from the court to that effect.
Yeah.
My lords, the other point is this. This argument being raised by Mr. Fitzgerald, as I understand it, is this. Although, in one sense, these sentences can be reduced, because you have the prison rules, you have the advisory committee, and you have the power of pardon, and so on, they are not properly reducible, because there's no merits-based review which is well established and transparent, taking place at regular intervals. As I understand it, that's broadly what his submission comes down to. There's not a proper system of review. There's a system of review. They can be reduced, but there's not a good enough system in place. Now, my lords, that just wasn't the argument at all below, and perhaps I can just explain why I say that. You can pick up the argument that was raised in front of Mr. Justice Barrow, Bundle 1 of the Volume 1 record. Page 161. My Lords, I'm going to the judgments rather than to the actual motions because they summarise the position. The motions are quite, some of them are quite long. The judgment is at 160, and Mr. Justice Barrow was dealing with the case of Mr. Bim Harry Ram, and you can see what the arguments were in front of him. First, the commutation.
Wait a minute, can you just pause a minute?
161.
Electronic bundle
61? It begins at 160.
No, I'm afraid I probably,
Oh.
I have it, yes. Yeah. Carry on, yeah.
Mm. 160 is where the judgment begins. 161, you can see what Mr. Bim Harry Ram's argument was. In paragraph 2, the judge sets them out. And you will see where the prison rules point comes in, subparagraph 5 over the page.
And the problem was, in his case, that despite the prison rules, there had been no such exercise.
Well, no, they had. What the judge found, perhaps I'm getting muddled up with Mr. Rajkumar's judgment, Mr. Justice Rajkumar's judgment.
I think so. If you look at 163 first,
Yes.
point 4,
Yes.
accepted by the state, there never has been a Rule
Oh,
282 review, but we'll get round to it soon.
Yes. Oh, well, that's right. I think it was in the other case there had been. In this case, there'd been no review.
Yeah.
They accept that. And then at the end of the judgment, 176,
Thank you.
he makes the declaration that we're entitled to a review. But that was the basis, that was, so to speak, the only basis on which the question of review was brought in at this stage. One then goes to the vast bulk of the appellants whose case was dealt with by Mr. Justice Rajkumar in Volume 2. And one can pick it up at page 615. Paragraph 10, 615. The judge refers to one of the rules. And then halfway down the page, on 616, some applicants complain as follows. The alleged interview does not sufficiently discharge the onus on the executive to accord the claimant the right to be heard. Moreover, there's no evidence the claimant was given the opportunity to respond to the statements made by other persons in relation to conduct or progress. He's never received notice of the existence of confidential reports. The entire process of review has therefore been conducted without his knowledge or participation, and procedurally unfair. The claimant has never received a proper review, and his rights have therefore been infringed. The court's entitled to denounce the procedure by which they're conducted and to refer the matter to the Minister of National Security for revision of the procedure, to bring it in line with Lewis. And then the judge over the page deals with the question of the right to be heard. And then page 618, he says at the top of the page, it goes without saying that such a review, that is, in accordance with the prison reviews rules, should accord with the basic principles of due process. And it goes on to say what that consists of. The prisoner's got to know what's, when it's going to be conducted, what's being considered, representations and time.
Yes, I mean, it's at least arguable that in addition, he should be told at the outset of his commuted sentence that this procedure is available to him.
Yes, well, my lords, I wouldn't necessarily dispute that. The real question is whether these sentences are cruel and unusual when you've got this system in place.
Yes, but it might be said that if he doesn't know at the outset that the system exists,
Well,
the significance of his incarceration is much more serious. That's the argument.
well, but that was the argument. I think the judge deals with it. I'll come to where he deals with it in a moment. But you'll see the judge explains in the second part of page 618 what the position ought to be.
Are they irremediable, these defects? Obviously. I mean, let's take Lord Sumption's
Yes.
point that on European Court of Human Rights Authority,
Yes.
you should be told at the outset. If you're not told at the outset, does that mean that the sentence is cruel and unusual and you're entitled to immediate release? Because you can never be told at the outset once it's not happened.
Well, no, in my submission, not.
I mean, we have to develop a slightly more sophisticated analysis, if that's right.
But my lords, the point I'm on here is just see what the argument was below. These were complaints. These were not complaints that the sentence passed on me was unlawful because there wasn't a proper system of review in place at the time. They were simply bringing what you might call a self-standing complaint, saying, well, I haven't had proper reviews.
Oh, I see.
And the judge deals with that eventually over the page at 619, the final paragraph. Sorry, it was alleged by some claimants they weren't informed of the result of the review or the reviews. No evidence as to whether the claimant was informed of the review or afforded an opportunity to make representations. There is evidence that part of the review process involved an interview with the applicant and a medical examination. Further, any disciplinary offences allegedly committed by the applicants were taken into account. I'm not persuaded that the conduct of the reviews was so secret and concealed from the appellants as they portray. I find that they have in some cases been less than forthcoming. For example, Henry, he goes on to say why they were less than forthcoming. But then he says, 8 lines down, in any event, well, I take the opportunity to clarify what the review process should entail in accordance with the Lewis. I find that the applicants had at least some input into that process in their knowledge and participation in medical examination, interview with prison officer, their knowledge of their commission or non-commission of prison disciplinary officers, I think must be offences, if any.
I'm terribly sorry, Mr.
Page 620.
Thank you. Got it.
And then the judge goes on in 620 to make his declarations. For future guidance. But he's not making a finding here that in fact there has been any serious breach of any rules by the prison authorities. He leaves the point slightly open.
Well, 621, it is quite clear that he wasn't considering the present type of argument that the whole sentence was invalid ab initio.
There was an argument that the re-sentenced, the substituted sentence were cruel and unusual punishment. It's recorded at 623, but it was a quite different one.
Yes. So what you've got here is essentially complaints saying, well, I didn't know these reviews were taking place. The judge says, well, I don't think you've been I'm not totally persuaded by the evidence. He leaves it slightly open, because, my lords, the evidence from the state was that the reviews did take place, and they were known about. And then the judge goes on to give guidance for the future. And he says, if there have been any breaches, it's not appropriate to make any orders. Now, my lords, there was no appeal against either Mr. Justice Barrow's finding or against Mr. Justice Rajkumar's. And one can see that if you go to volume 3, at page 727. Paragraph 4. And you'll see Roman numerals 1 to 5, those are the issues.
Sorry, which page?
Sorry, it's 727. And then likewise, you can see an expansion, so to speak, of some of the grounds at page 732, paragraph 14. Sorry, my lords, sorry, forgive my lords, that's not the appeal. I should take paragraph 15. Issues not in dispute.
Yeah, that's the judge.
And you'll see one of the issues not in dispute is the judge's declaration in relation to prison rules. My lords, for your note, the notice of appeal, you can see, I think at page 641 in this same record, and it's a fairly comprehensive document. I think I'm right in saying there's no reference to this sort of ground. So the court, in other words, the Court of Appeal's summaries would appear to be accurate for all material purposes. My lords, the Court of Appeal deals with the question of reducibility briefly and in passing at page 770. And it's in the context, I think one has to go back to page 763, paragraph 60, the sentence of imprisonment for natural life, or perhaps more appropriately 762. Can the sentences imposed on the appellants in these matters be legitimately described as lawful conditions? And paragraph 81, you'll see the argument that was advanced before the court. Which was essentially, these sentences are just totally irreducible. And the concession by the state in paragraph 83, there's no prospect of a sentence coming to an end, it can't be lawful. The Namibia case of Tisseb is relied on, and then paragraph 85. We agree with the reasoning of the judge in Tisseb that a life sentence cannot be justified if it effectively amounts to a sentence which locks the gate of the prison irreversibly for the offender without any prospect, without whatever, of any lawful escape. That's not the position in Trinidad and Tobago because of the operation of the prison rules, the ability of persons to apply for mercy, and so on. My lords, one might add the express right to repetition, which was granted to each of the appellants under the President's original orders. So that's the issue before the court. Now, my lords, this question of a merits-based review and the legality of a life imprisonment or 75-year term when you haven't got a merits-based review or guarantee of a merits-based review simply hasn't been raised at all. And that means no evidence has been addressed to precisely what is the nature, the precise nature of the reviews and to what extent are they merit-based reviews. That issue wasn't there before the court.
Well, there is a bit of evidence, isn't there?
Oh, there is. There is evidence, but not specifically directed to... I mean, there's general evidence about the reviews.
Are the two pages that Mr. Fitzgerald took us yesterday, 402 and 465, are those where it is to be found? That's in the record.
Yes, I was going to take you to...
Oh, I'm so sorry.
I'm going to take you to the reviews, just to show, in fact, they shouldn't be castigated. I will take you to those reviews that have been carried out.
Then I'm sorry.
But my point's an earlier point. The specific point that's now being made by Mr. Fitzgerald wasn't made below. So the state hasn't had the opportunity to say, well, look, when we do these reviews, we do specifically focus on A, B, and C, or whatever. So the question hasn't been raised for the state to put in evidence, and just as importantly, the local courts haven't had any opportunity to deal with the point. And I submit that is a very important point, because they're the courts who carry out the sentencing, not just in death penalty cases or life imprisonment cases, but long imprisonment cases of all sorts. And they, in my submission, must have some input into this question.
Presumably, now that there is a power under Section 69A of the Interpretation Act to attach a tariff period to a life sentence, not of course for murder, but for other offences, there may, I just don't know, but there might be some sort of system in place for the application of the prison rules to those cases.
Yes, my lord, I cannot answer.
You just don't know.
I don't know off the top of my head whether that's correct or not.
Yeah.
My lord, just turning to the facts. Well, perhaps before I do that, I should just take you to the prison rules just to see what they do provide for. I think they're in Bundle 1 of the authorities. In tab 3. Um, 281. Case of every prisoner serving a life sentence shall be reviewed by the Governing Council, 4th, 8th, 12th, 16th and 20th year of the sentence. Well, there's an express provision for review of life sentences. And, my lord, it's common ground that would apply to commutations.
Yeah.
And it's common ground, is it, that also applies to the 24th, 28th, 32nd year and so on?
Well, my lords, I don't know if it is common ground, but it must do.
Well, that's certainly what the judge found.
Yes.
I'm not sure on what basis, but it wouldn't make much sense otherwise,
No.
but it does involve a certain amount of
Yes,
manipulation.
bad luck. You haven't got out in 20 years. You just have to stay now. My lord, my lord, I don't think anyone's contending that could be right.
No.
Review of long sentence.
So we should mentally insert the words "and so on"
Yes.
at the end.
Yes.
And 4 yearly thereafter,
Yes.
if necessary. Okay.
Review of long sentence. In the case of every prisoner serving a term of imprisonment exceeding 4 years shall be reviewed by the Governor at intervals of 4 years or shorter periods, if deemed advisable. So there's express provision for review. And then remission at 285.
Yeah.
Which is important in my submission. Well, my lord, it is important because it gives some idea of what is going to be taken into account. With a view to encouraging good conduct in industry and to facilitating the reformative work of prisoners, arrangements shall be made by which a convicted prisoner serving imprisonment, whether under one sentence or consecutive sentences or under any such sentence or sentences, and the remnant of a previous sentence, for a period exceeding 1 month, may become eligible for discharge when a portion of his term of imprisonment, not exceeding 1/3 of the whole term of imprisonment, has yet run.
But that's remission for good conduct during the sentence, which,
Yes.
whereas review of long sentences is concerned with the question whether it's necessary
Yes.
to detain the man any longer. Full stop.
But this will give an idea as to what is going to be taken into account on your reviews. I mean, you are being...
Is it, yes, that's what I was going to ask. Is it your case that remission is one of the things that the 4 yearly review actually considers?
Well, my lords, I don't know if... Well, I don't think there was evidence specifically to that effect, but I will take you to the reviews in a moment.
Thank
I
you.
mean, it's difficult to regard it as relevant to that because the remission provision applies to any sentence of whatever length.
Yes.
So if you had a 3-year sentence, you could still knock 1/3 of it
Yes.
off it for good behaviour.
But let's say you've got an 18-year sentence, then after 6 years, the remission provision kicks in, and I submit that there'd be no reason why, on the review, that they could take into account good behaviour and so forth. But, my lord, in any event, this obviously doesn't apply to life sentences, I say obviously, but on the face of it doesn't apply to life sentences, but it does apply to a 75-year term, for instance, or to a long term.
Yeah. Can you just in case we get to this point, can you just go back to 281 and 282 for
Yes.
It's pure terminology and personality. But in case we have to consider whether and who has an obligation to do what,
Yes.
governor, in this context, if I've read the rules rightly, actually, to all intents and purposes, means the minister who also considers the exercise of the prerogative. Am I right about
Yes,
that?
my lords, yes. I mean, governing council effectively means president, but this is all part of it goes up.
There's a rather complicated route to it in the rules, but what it doesn't mean is the local governor of the prison.
No, oh no. And my lords, there is some evidence as to how in practice
Yes,
the
there is.
reviews were worked and who they landed up with at the end.
What I haven't worked out is who the council are for the purposes of 281, because there is no other reference to the word council that I've discovered in the prison rules. The search facility may, of course, be defective, but I haven't found it.
The council.
Yes, I would have thought that's probably what it is. It's a reference to the effectively the
Local Privy Council.
the president. Or the,
I imagine it's the President's Council.
yes, President's Council, the advisory committee. Yes.
Well, whether it's the same as the advisory committee or not is a different question. But anyway,
May or may not.
it's someone.
Presumably there's
Yes.
a discretion as to the appointment.
Right.
It's a largely ministerial body, but not entirely.
Yes.
Anyway,
My lords, those are the
the reviews are not done by the advisory committee on the evidence, except, is this right? Get it right. No, I'm sorry, I've lost it. There are some very few which are.
My lords, I was going to go to one.
All right,
No. But my lords, I can't remember which. I was just going to go to one to. I was just going to go to the evidence, which explains this, and then just to a couple of reviews from which one can work things out as to what's going on.
Right, thank you.
I think the first. This is one of the statements. The first is in bundle 2, at page 378, which is one of the affidavits of Mr. Edwin Grell. And one can pick it up in paragraph 6 when he explains what happens to a prisoner upon commutation. He gets transferred to the maximum security prison. And then paragraph 7, he explains what the process of review is. And he says, I was just picking up a point that my Lord Assumption made a moment ago, he says upon committal, paragraph 7 of the claimant, to the prison to which he was dispatched, the claimant was informed of all his rights, responsibilities and so forth, pertinent to his sentence. He was also informed of his reviews. So that's what he says. I don't think there's a finding of fact either way on it. And then paragraph 8, he explains the nature of the review. Paragraph 9, he explains what happens to the review. I think that's where I got the advisory committee point. My lords, of course, in one sense, this is invoking the President's power of pardon.
So if there's a recommendation for early release, then to the advisory committee.
Yeah, up it goes to the advisory committee.
Although it's the minister who makes the decision formally.
Yes. And then he goes on to say in paragraph 10 what happened in this particular case. But he says in paragraph 14, a sentence I can't resist. The first sentence has a wonderful ambiguity to it, depends how you read it. But My Lord, that's, just moving on in the same bundle, page 424 is another description. Sorry, it's not a description, it's... Oh, this is a report. This is a report made on Mr. Lendore. And it's just helpful to look at the, what you might call the headings. First of all, they consider, well, what's he been convicted of? They consider the sentence, refer to the sentence, and you'll see the headings: personal information, prison history, disciplinary matters, involvement in prison activities. My lords, one wonders whether they put these in simply because of what you see in the remission provision, 285. Communication, medical history, and then conclusion. Lendore has benefited from some of the rehabilitation programs offered at the maximum security prison. He has also exhibited a high level of agility in both sports and recreation, and so on. And then you drop down to the final paragraph on the page. Lendore is quite a pleasant individual, and one can only wonder why an individual of such a nature will get himself involved in a heinous activity such as murder. Probably he could have been influenced by his peers. He's demonstrated a high level of patience in comparison to much of his peers in the prison. This is reflected by his compliance and adherence to the rules and regulations of the prison. In conclusion, I believe that consideration should be given to this inmate in terms of early release based on his conduct in prison. He has shown that he has the ability to improve himself. If given the opportunity, his calm disposition is a credit to his behaviour. He's always pleasant, obedient, well-mannered. And it's signed by the Superintendent of Prisons, and you'll see this review, I think, was a review carried out in November 2008, from page 424, which is 10 years or so after his 75-year term. So that's the recommendation. Now, my lords, the reason I submit this is at least to some assistance, because it does show that these aren't just sort of, totally pro forma reviews when they take a look at your medical condition and ask you, have you been doing a bit of sport? They are actually considering, should he be released? And here is actually a recommendation saying he should be released. Now, in fact, this recommendation was disagreed with. If you go to page 452, and the problem, I dare say, is that Mr. Lendore wasn't aware of the superintendent's communication, and then the disagreement from the Commissioner of Prisons, which you see at 452 to 453. It might be said perhaps he should have been made aware.
Yes, it's, yeah.
This is, I suspect, the document which Mr. Fitzgerald was
Exactly.
being...
And you might say, well, that's not a particularly powerful reason for keeping someone, or as well, for keeping someone in prison. Now, my lords, I'm not here to defend that particular decision, but I'm here simply to say the point is given serious consideration. The criticism, which I think is covered by Mr. Justice Raj Kumar's judgment, is, well, this is taking place without the man knowing that he's actually had a very positive recommendation, which has then been squashed by a not particularly convincing line of reasoning from the Commissioner of Prisons. Well, that's a different point. It doesn't make the whole system cruel and unusual.
Is Lendore alive for a 75-year?
I think he's a 75-year man.
Right, so even the Commissioner is contemplating at least the possibility of release at some stage, but not yet.
Yes.
Preparation for re-entry into society.
Yes.
Yeah.
Well, there's just two other references I wanted to take you to. Another is an affidavit in the same bundle at page 511 from Jocelyn Rampersad, and it's paragraphs on page 512, paragraphs 5 to 9, where, if I can just ask you, my lords, to read those paragraphs to yourself, where she explains what happens with petitions for
So which
early
paragraphs?
release. 512, paras 5 to 9.
She's in the ministry, isn't she?
Yes.
Yeah, okay.
Oh, she says in paragraph 6 that the sort of documents we've just been looking at are provided to the
Yes.
petitioner.
Ah, yes. Well, if he petitions for early release, I think.
I see. Yes, yes.
Yes. So, which obviously is right. But my lords, my understanding is these reports were called confidential reports. In other words, you wouldn't see them in the normal course unless you petitioned for release.
So not on the regular reviews.
Yes. So you'll see there, my lords, that explains various people have been released early. And this, I make this point, obviously, to make the point, this isn't some sort of de jure, but it never happens in real life, right? It happens.
Well, one has.
Two.
Yes. Well, and 8 to 9, I think.
Mr. Sukal failed.
Yes.
Only on account, it said, of his ill health and
Yes.
inability of anyone to look after him.
Quite.
I mean, there clearly are problems. This may be what was behind the further education point about simply deciding that there's no justification for keeping someone any longer and dumping them on the outside world if they are not either mentally or physically in a position to conduct any kind of normal life.
Yes.
Am I right, Mr. Knox, in understanding there is no release on licence system in Trinidad?
I think that's right, my lord. No.
And is there any post-release counselling, supervision?
I cannot answer that question, my lord.
I suspect very little.
I would have to take instructions, my lord. Oh, well, Mr. Delson will know.
Thank you. Yeah. Well, it's a question of what infrastructure there is or isn't.
My lords, the last reference, if I can just ask you to read page 516, another affidavit of Mr. Edwin Grell, paragraphs 8 to 10. 8 to 11. It contains 516 to 517. I think it did. That makes the point there's no parole.
All right, thank you.
Now,
And it also says in 4 that they are reviewed at 4-year intervals after the 20th year.
yes. My lords, I submit, if one just looks at the facts without reference to the ECHR authorities, I submit that on any sensible view, life imprisonments or very long terms of imprisonment are reducible. You ask the man in the street, he'd say, well, yes, of course they can be. It happens in real life. They're not shams, these reviews. So, my lords, that's what I say generally. If I can deal with the merits of the point to the extent that it is a point which should be covered in your lordship's judgment, the first point I make is this. It would be, I submit, quite unfair to criticise the state for the sentences which it passed in the 1990s on the basis of new developments in the law in ECHR authorities, essentially since 2010 onwards. That sort of retrospective approach, in my submission, cannot be right. to say that what no one thought of at the time as being cruel and unusual, in fact, all along was cruel and unusual, in the light of what we now believe to be the case, and therefore to castigate the state for that. And
Well, I think that there are two steps there. I mean, the first step has undoubtedly been taken in the context of death penalty cases, hasn't it? Lord Bingham, at some point, examined cases where a different attitude had been taken as to what was cruel and unusual. And he said, well, they were simply wrong, and it always was cruel and unusual. I'd have to identify.
I'm going to come to that in a moment. That was the case of Bow from the Bahamas, where the problem was that there was, for a passage of time, a constitution which didn't have a savings clause.
Yes.
Which meant that, as at that moment, strictly speaking, the mandatory death penalty was unconstitutional.
Yes.
There's then another constitution that replaces that, which does have a savings clause.
Yes, right.
As a result of which, everyone continues to believe that, of course, the mandatory death penalty is perfectly lawful. No one having thought of, back in the 1970s, when the previous constitution was in place, that it was unlawful.
But the constitutional prohibition of cruel and unusual punishments is a classic example of an ambulatory
Yes.
right. What is cruel and unusual in the 20th century is not necessarily the same as what would have been cruel and unusual 100 years earlier or 50 years later.
Yes. But absolutely. But my submission is that what you might call the building blocks, I think there's a phrase used by Lord Bingham in Bow, the building blocks for saying that the sentences passed by the President in the late 90s were cruel and unusual or unlawful, simply weren't there at all in the late 90s. This wouldn't have occurred to anyone.
Well, you get some support from in a different context, a decision in Newbold in the Bahamas, where we did accept that proposition, but it's a difficult area.
Yes, but by laws, the question here is whether the state then imposed cruel and unusual punishment. Right. I think there's no possible basis for that, where no one thought at the time, there was no jurisprudence which would have suggested at that time that this was cruel and unusual. Indeed, the opposite, the jurisprudence was all the other way.
Is that the question, or is it whether they are currently subject?
Well, that, my lords, that might give rise, if this were a live issue, then one might be considering what remedy to grant. One could see the point. Well, 20 years ago this was not cruel and unusual, but now we do regard it as cruel and unusual. To what remedy are you entitled?
Well, the remedy would be correction so far as feasible for the future.
Exactly.
Which is what we were unable to do in Newbold, but which you could do in this situation if it involved improving the review procedure.
My lords, my submission is that would be as far as it could go. Yeah. The notion, for instance, that these were cruel and unusual punishments ab initio and should always have been seen as such, therefore they should be entitled, let's say, to some constitutional redress, such as damages, for the term they've so far served, I submit would be unthinkable. The most it would go to is the point your lordship makes. Well, now that we see these things differently, we will, as from now on, make some declaration and so forth. But, my lords, in this case, I come back to the academic point. Where's that going to take things? So, my lords, I say that in relation to the sentences actually imposed. My lords, dealing with the matter more abstractly, what could now be done, let's say, on a remission by the High Court or by the Advisory Committee? What could now be done? The first point I make is this, is that the European Court of Human Rights Learning is, in my submission, not a safe guideline for Trinidad and Tobago. It's the obvious point, it's not a member of the treaty, and it might be rather bewildered to find that, although it's not a member of the treaty, nonetheless, its own constitutional provisions are being read almost as if you have to transplant all the ECHR learning. I submit that cannot be right.
It cuts both ways, that argument, because I get the impression that Caribbean courts of appeal in particular are quite keen not to be thought to operate a system which is not in touch or in line with general international standards. In other words, they wouldn't wish to be thought to be entitled to lower standards.
Well, I would accept that, my lords, but it really comes, that my answer to that is the problem here is, I think, a phrase my Lord Reid used, that the recent ECHR correspondence, there are twists and turns. I mean, it can hardly be said to be settled exactly what it is. There's a lot of debate about it, precisely, and I think in Wellington, Lord Hoffman basically says, well, you know, there appear to be different strands, and they're all arguing amongst themselves.
Well, the problem really is that the convention combined with the jurisprudence of Strasbourg is not simply a body of rules. It's a dynamic source of law by virtue of the way that Strasbourg operates the living tree doctrine.
Yes.
And there may be particular problems about inserting a dynamic source of law into the framework of a constitution. I mean, of course, it's perfectly fair to say that particular decisions may be regarded as persuasive, just as decisions by, for instance, Canadian courts under the Charter or sometimes United States courts would be.
Yeah.
But that's about as far as it goes.
Well, my Lord, that is precisely my submission. It is, one can look at these cases as some sort of guideline as to what does amount to cruel or unusual punishment, but one certainly shouldn't slavishly follow them and say, right, well, that's what the ECHR decided in that case. Let's just transplant that to Trinidad, especially where the jurisprudence is so shifting and unsettled.
What we can see, I mean, by comparison with our own approach in the UK, there's a much wider consideration of comparative law in these judgments, looking at courts in Africa, for example, who we would rarely look at. And one can see they are very interested in international standards.
Yes.
And obviously the ECHR judgments form part of that consideration. But I think the mistake would be to treat them as having quite the same status as they do if one was considering a question in UK law.
Yes. Well, in my submission, it would be wrong to do so. I mean, in UK law, you're obliged to take them into account, but there's no such requirement in Trinidad and Tobago. I accept, of course, you can look at them like a Canadian case and say, well, that's an interesting line of reasoning, that makes sense, and it must apply in Trinidad too, just as a matter of legal logic. But
there's a broader point, isn't there, about the application of that principle to the cruel and unusual punishment principle, which is that what is cruel and unusual is very much a question dependent on the social values of the jurisdiction in question. They may in many respects be the same as they are in Europe, but in other respects not.
yes. Well, and
how are we to judge?
Sorry?
How are we to judge?
Well,
We need the
that's a
input
very
of the courts
difficult
of the
view,
jurisdiction.
especially without any guidance from the courts below.
But I think I see that point.
Yeah. The prison rules suggest that there are still provisions for corporal punishment in prisons in Trinidad. Is that right?
I'm not sure whether it's ever...
May have gone now.
It may have gone, yeah.
Looks as if they've gone. All right. Thank you.
But my Lord, perhaps the shorter point, even the ECHR jurisprudence recognises that there, what my learned friend calls, there must be a margin of appreciation for different states. Well, my lords, if that is right, the logic of the position is up to the state, each individual state, within a certain limit, to come up with its own system of reviews and so forth, as long as they comply with the minimum standards.
So can we come, you'll cut to the chase as to which particular aspects of review you accept and which you don't accept?
My lords, I think we would accept
as aspects on which we should insist.
Well, those which were conceded below, I think Mr. Hossain, my predecessor in the Court of Appeal below, accepted that if a sentence is really irreducible and it comes to the same thing as throwing the keys away, well, that would be cruel and unusual, because that means the man will simply die in prison and he has got no hope whatsoever of living outside prison.
I think my Lord's question was directed to a different issue, namely, what elements of the review do you consider we should direct should be in place?
Well, in my submission, you shouldn't yourselves be making any direction as to what the reviews should be. I mean, Mr. Justice Raj Kumar has already set out in his judgment how the reviews should be carried out. The prison rules provide for reviews at certain intervals. And in my submission, there's no need for the board to make any recommendations as to what the nature of the review should be.
Well, I mean, the two aspects of some of the ECHR cases which may be germane here are, first of all, the requirement in at least one case that there should be a statement of principles on which the discretion is exercised,
Yes.
a publicly available statement, and secondly, that the prisoner should be in a position to guide his conduct in prison by reference to
Yes.
such a statement, which suggests that it would have to be available to him from at least a very early stage of his incarceration. Now, those are aspects of the jurisprudence of the Strasbourg Court which may or may not be applicable, and breach of which may or may not constitute a cruel and unusual punishment by the values applicable in Trinidad.
Yes. Well, my lords, one of the problems, because we haven't had this case raised, the case raised against us in this way, I'm not in a position to say exactly what as were the standards are, and to what extent the condemned man is told.
Maybe that we aren't either, precisely because although we are sitting as a Trinidadian court, we do not have the same access to Trinidadian values that the local courts would have,
yes.
which reinforces your point about the value in this kind of debate of the views of the courts below.
My lords, I think all I'd say is that even if, let us say, even if this is something which it would be desirable for there to be, maybe there should be, the absence of it would not, let's say, the absence of, as were, prescribed set of standards or criteria which are made known to the condemned man before he starts his sentence. That mere absence in my submission would not make the sentence cruel and unusual.
Can I just ask a slightly similar but slightly different question, which arises, I think, from the submissions that Mr. Fitzgerald made to us about this? His fundamental submission, I think, is that at the stage of each review, or at least less frequently, but certainly from time to time, there has to be a consideration, as he would put it, using the Strasbourg language, whether there are any longer any penological grounds for continued detention.
Yes.
Now, don't answer that just yet, but that's question one. Do you agree that that is a necessary requirement of a non-cruel and unusual punishment?
No.
If it is, it raises the, as it were, contained question of whether one of the things that a review has to look at is the circumstances of the original offence, and thus the level of appropriate punishment for it.
Well, my lords, again, I don't think I'd be in a position to accept that as in the sense that without that, the punishment becomes cruel and unusual. I wouldn't accept that. These may be things which should be put in place, but they are matters for the local legislature. I mean, one otherwise is getting terribly close to legislating.
Yeah, well.
You can't have the life imprisonment unless it's tantamount saying you must impose these regulations in real life. But my lord, my lords, I do submit that the ECHR jurisprudence doesn't go as far as what my learned friend says it does. In my submission, if I can summarise in a few words, its essential proposition is a sentence must be reducible with a real prospect of release, de facto and de jure. It then says also, laws which restrict or unduly restrict such a prospect will themselves also make the sentence unlawful. Hence the Vintner case, the Winter case, which was essentially about the English law, I can't remember, section 30, and an order passed under it, which unduly restricted the opportunity for certain types of people to get a release. And that was the context of what is said in Vinter. In other words, you cannot, if Trinidad passed a law saying people who are convicted of murder in the course of a robbery will serve all their life in prison, say, unless they're terribly ill, in which case they'll be allowed out for the last 5 days.
Humanitarian.
Yes, exactly. If there was some such, that would be an unfair restriction, and I would accept that. But in my submission, in other words, they prescribe negative things. You're not allowed to have unfair limits. But they do not, in my submission, on a proper reading, say that all states must have these positive provisions, such as a merits-based review on penological grounds at certain intervals. They don't go that far in my submission. They simply say this, effectively, they say this is what they think perhaps should happen, but they're not going to legislate for each individual state's criminal justice system.
So is that the main point on which you take issue? I mean, Mr. Justice Raj Kumar went quite a long way in specifying that whether you're talking about a review by the advisory committee stroke president or whether you're talking about a prison rules review, procedural due process should be followed, and in specifying what it was.
Yes.
Namely, you should know when it's going to happen, you should know the material being considered, you should have the opportunity to perform all representations and sufficient time, etc. You don't quarrel with any of that? No. Oh, so what you quarrel with is what? That any suggestion that there should be a specification of the factors which are taken into account.
Some sort of publication, as it were, which involves two stages, really, establishing factors. The state has to work out the factors which will be taken into account. And those will include, I think I'm right in saying, if Mr. Fitzgerald's right, one of the things we will take into account is whether you have served, as it were, enough time for penological purposes.
That's what he says.
Yeah.
They wouldn't have to be exhaustive, of course.
No.
All that, if he's right, he would say, I think, that they have to do is to say that we will address these questions.
Yes.
But how can any sensible reviewing body avoid addressing that question? And I'm not quite sure what it suggested should be said by way of specification of the factors. Once you list them, you're not presumably expected to weight them. What I don't understand is what the real problem is here, because it may be that one wouldn't receive very much except a general list of the factors which would actually help the reviewer tick them off and say, I've considered each of those.
Well, my lords, I agree, but where would it really take one? You can simply publish all the factors. But
it does at least focus the mind on each of the
factors.
factors, whether you are considering punishment or deterrence, or whether you're considering rehabilitation, or what you're considering.
My lords, this may be a way of making what you might call the review system fairer.
Yes.
So a man has a slightly better idea of what's going to be taken into account on the review system.
Yes.
So he knows what he ought to do.
All he has is the assurance the reviewing body will look at each of the relevant penological factors.
Yes.
I mean, do you object to that?
Well, I don't object to that, but I object to the notion the sentence is cruel and unusual if you don't
Yes.
have it.
Well,
that's what it comes from.
I can
That's
see
the
that.
issue we're on.
Basically, the only thing that you would regard as cruel and unusual is a system in which there was no possibility of reduction at all.
Yes. Well, no serious possibility. I mean, it has to be a real possibility.
Short of that extreme situation, your submission, as I understand it, is that the result in law is not, of any other defects, is not that the sentence either always was or becomes cruel and unusual, but simply that there is, you judicially review whatever the defect turns out to be.
You could say, look, I've had this review carried out, and I see you've taken into account these factors, but you ought to have taken into account the fact that, bearing in mind what the nature of the offence was, I've done my time. And it would be a matter to be decided, so to speak, on a case-by-case basis by judicial review, rather than by sweeping all sentences which were passed like this are unlawful.
You see, one tends to be conditioned by the English experience, although one can't help it, where you have release on licence of lifers,
Yes.
which is a very big difference, with a genuine possibility of recall
Yes.
for breach, and where therefore the principal question, and you have a tariff, so you don't get to release until as it were, the punishment period, as it's known in Scotland, I think, has been served. So that caters for that "has he done enough" question. And the remaining question is nearly all risk associated with release. But you see, in a jurisdiction like Trinidad, you've got to blend all these different factors somehow or other.
Yes.
Yeah.
My Lords, I do submit that whatever the temptation to legislate, it's one that should be resisted. The simple question before the board, to the extent it is, I'm exiled from my previous position, it's too difficult to consider ab initio without the views of the local courts. The simple question for the board is the absence of the things Mr. Fitzgerald says should be there, is that something that makes these sentences cruel and unusual, either ab initio or at least from now on? My answer to that is in both cases no. And I also submit that's not what the ECHR jurisprudence suggests either. My Lords, I was going to just go briefly to Wellington and Vinter, and briefly to Harkins, and then I'm done. My Lords, can I go to Wellington? I just want to emphasise one or 2 points. I think Mr. Fitzgerald took you to some of it yesterday, and it's in bundle 4. Tab 48. And my Lords, the reason I show this to you is my learned friend says, oh, this has been overtaken by subsequent ECHR jurisprudence, which I say, but this is 2009. And this gives a good example of how dangerous it is to just transplant ECHR jurisprudence. When here's a House of Lords decision from 2009, which
2008, yes.
2000.
Yeah.
And which one might well say, well, why, when you're looking at the position in Trinidad, why should you, so to speak, prefer an ECHR decision in 2014 to a House of Lords decision in 2009? Wouldn't be immediately obvious to the man in the street in Trinidad when deciding what's cruel and unusual, taking into account local standards, or even international standards. My Lords, you were taken to 2566, I think, paragraph 8. And my Lords, I take you to it simply because I submit is a very useful reminder of just what the position was in Kafkaris, which concerned a mandatory life sentence for murder. Only the President could order the release of such a prisoner, so it's only an executive power, either by exercising power of mercy or by ordering release on licence. So, my Lords, just pausing there for a moment, my learned friend says there has to be some sort of either judicial body or indeed independent body, entirely independent body in charge of the commutation process to make a sentence reducible. I submit, well, that's just flatly contradicted by Kafkaris. Now that Kafkaris you have in Cyprus, perhaps not surprisingly, not a totally different system as you find in the Caribbean. And then Lord Hoffman refers to the majority judgment in that case. What counted as an irreducible sentence, the court said in para 98, where national law affords the possibility of review of a life sentence with a view to its commutation, remission, termination, or condition of release of the prisoner, this will be sufficient to satisfy Article 3. The courts found that this is the case even when the possibility of parole for prisoners serving a life sentence is limited. Follows that a life sentence doesn't become irreducible by the mere fact that in practice it may be served in full. It's enough for the purposes of Article 3 of the life sentence de facto reducible. In my submission, that is it. And you look at the existence of a system of release, you look at the system to see if there really is reducibility in practice. And then paragraph 12, Lord Hoffman adds the rider, conclusion I draw from the court's guarded statement that irreducible sentence may raise an issue under Article 3, and that the existence of the system for release was a factor to be taken into account in assessing the compatibility of a life sentence with Article 3, is that an irreducible sentence will not necessarily infringe it. My Lords, there's also a passage from Lord Brown's speech which I would like to show you, paragraph 78. Where he gives his interpretation of Caris and Bieber, paragraph 78. What I deduce from all this is that in reality the Strasbourg Court does not consider the question of irreducibility as a matter wholly distinct from the question whether some body, judicial or not, will one day take account of the individual circumstances of the prisoner's case. The potential vice of a mandatory life sentence is that no one may ever consider the defendant's individual circumstances with a view to deciding whether in fact he should remain in prison forever. Providing that at some point during the sentence this will be properly considered, then the sentence is not to be regarded as irreducible. It will, if appropriate, be reduced when the individual facts come to be considered. The majority of the Grand Jury in Kefkaris found this to be so with regard to mandatory life sentences generally in Cyprus. In Bieber, the Court of Appeal found it to be so with regard to life sentence prisoners subject to whole life terrorists in the UK. In so holding, the Court of Appeal relied on the Secretary of State's power of compassionate release in Section 30, and so on. Given, however, that this power is used only sparingly, to my mind, the altogether more important factor compelling the conclusion that such sentences are not to be regarded as irreducible is that when originally the whole life term was fixed, the prisoner's individual circumstances, including the circumstances of his offending, will have been considered and will have been thought by the Court of Appeal to merit that degree, and so on. But, my Lords, in my submission, these are authorities, this is a clear authority, that you don't have to have more than the real prospect of release. Your point will be, it will be considered at some point. My Lords, going to Winter, my Lords, this is, I think from the European authorities, this is the one that really matters, because it was a comprehensive review. I mean, when we read it, they've looked at the international jurisprudence. I don't think they've looked at America, actually. But apart from that, they've looked around the world, and it's a very thorough judgment. But in my submission, it doesn't support my learned friend's propositions at all. It's in tab bundle 5,
Tab 60.
tab 60. My Lords, can I just go to what the problem was, which is being considered, and that's in paragraph 42 at 2941. It was Section 30 of the 1997 Act, which provided that the Secretary of State, paragraph 42, Section 30 provides that the Secretary of State may at any time release a life prisoner on licence if he is satisfied that exceptional circumstances exist which justify the prisoner's release on compassionate grounds. The criteria for the exercise of that discretion are set out in the Prison Service Order, and essentially, as we read down the page, you first of all have to satisfy the fact that you're suffering from a terminal illness and you're likely to die very shortly, and then all various other restrictions as well. It's very unlikely in that short time before you die you're going to reoffend and things. So it's very restrictive. So in other words, this statute taken together with that order meant that in real life you had virtually no chance of ever getting out of prison at all, save for the purpose of dying. Now, my Lord, that's obviously a very serious restriction, and that was the issue in the case which prompted all the considerations. The paragraph, moving on to paragraph 108 to 109, which is, I think, on 2963. Perhaps I should start at 107. However, as the court also found in Kafkaris, the imposition of an irreducible life sentence may raise an issue under Article 3. Then it goes on to consider there are two things that need to be considered. But, my lords, in this passage, the court approves Kafkaris. It doesn't say I'm moving away from Kafkaris. In particular, 108, a life sentence does not become irreducible by the mere fact that in practice it may be served in full. That's the first point. In this respect, the court would emphasise that no Article 3 issue could arise if, for instance, a life prisoner had the right under domestic law to be considered for release but was refused on the ground that he or she continued to pose a danger to society, and so on. And then dropping down to 4 lines before 109, the mere fact that such prisoners may have served a long period of imprisonment doesn't weaken the state's positive obligation to protect the public. And then 109, second, in determining whether a life sentence in a given case can be regarded as irreducible, the court has sought to ascertain whether a life prisoner can be said to have any prospect of release. And this is the important point. Where national law affords the possibility of review of a life sentence, with a view to its commutation, commission, termination, and so on, this will be sufficient to satisfy Article 3, Kafkaris. 110, there are a number of reasons why, for a life sentence to remain compatible with Article 3, there must be both a prospect of release and a possibility of review. The court then goes on to consider why that must be the case. My lords, that in my submission is the essential reasoning. One moves on to paragraph 109, general conclusion in respect of life sentences, 119, sorry, page 2966. For the foregoing reasons, the court considers that in the context of a life sentence, Article 3 must be interpreted as requiring reducibility of the sentence, in the sense of a review which allows the domestic authorities to consider whether any changes in the life prison are so significant, such progress towards rehabilitation has been made in the course of the sentence, as to mean that the continued detention can no longer be justified on legitimate penological grounds. Can I just pause there for a moment? The important word in that sentence is allows. There must be as requiring reducibility in the sense of a review which allows. So in other words, as long as you've got a system review which allows for that to take place, you're all right. What is not all right is if you've got a system review which prevents that from taking place.
Those factors at 119
yes.
Appear to be focusing not on the original circumstance of the original offence or its gravity, but on essentially the conduct of the prisoner afterwards.
A change. But, my lords, I emphasise the word allow. I mean, they're not saying you have to have, they're not saying you positively have to have some such regulation in place. They're just saying as long as this can happen, fine. Because, my lord, otherwise they'd be departing from Kafkaris. If they're imposing further restrictions as to what, imposing further requirements, in my submission, all this is saying is, well, as long as there's a system which allows for this. And then 120.
Well, it allows it. It can't be a matter of pure whim whether it takes place.
Well,
Surely it's got to be a system which ensures it when appropriate.
Well, my lord, this is part of the difficulty of reading these things as statute, but in my submission, these words are carefully chosen not to say, you have to have it.
Well, there isn't really a difference, is there? Because if the law confers a discretion on an authority, it's basic public law that the discretion must, at least, a consideration must at least be given in an effective manner to whether the discretion should be exercised.
Yes. I think perhaps, my lords, I'm grateful for that, my lords. The point I was on was that you don't, so to speak, have to have a prison rule which says this in terms.
Well,
we will have a review which will take into account the following.
Have to rely on general principles of public law.
Yes. And then 120, however, and my lords, I submit this margin of appreciation point is important, would emphasise that having regard to the margin of appreciation, which must be accorded to the contracting states in the matters of criminal justice and sentencing, it is not its task to prescribe the form, or executive or judicial, which that review should take. This being said, the court would also observe that the comparative and international law materials before it show clear support for the institution of a dedicated mechanism guaranteeing a review of no later than 25 years after a life sentence. This is general guidance rather than it's cruel and unusual unless you have it.
Well,
and 121.
121 effectively says that if you don't,
don't provide for the
don't have it
possibility.
at all, it will be.
But if you don't provide for the possibility of
Yes.
such a review, this is all going back to Kafkaris. As long as the review, as long as it's possible, you're compliant, as it were, or not. It's not cruel and unusual, as long as it's possible. But you don't have to have a sort of raft of specifically set out rules, which everyone knows in advance. And so that's why I say this case doesn't advance matters beyond Kafkaris. It actually is saying the same as what Kafkaris said. And the same, I think, is in paragraph 122, although there is a slight ambiguity right at the end of 122, where you can see, if you took that on its own, you could see there might be a problem. It's the last two sentences. A whole life prisoner is entitled to know at the outset of his sentence what he must do to be considered for release and under what conditions, including when a review of his sentence will take place or may be sought. Consequently, where domestic law does not provide any mechanism or possibility for review of a whole life sentence, the incompatibility already arises at the moment of the imposition of the whole life sentence. Now, the last sentence doesn't actually follow from the previous one. It's difficult to know what to read into that, but in my submission, the guiding factor in this case is the approval of Kafkaris. And when it says a whole life prisoner is entitled to know, that's really more that's what you might call guidance. But it's not saying, well, if for some reason he doesn't exactly know, or you haven't made it plain to him, that the penalty is necessarily cruel and unusual. It can't.
What are you worried about that proposition? I mean, well, if on the face of it, the sentence as passed is one which is, offers no possibility of review, on the face of it, why shouldn't it be a breach of Article 3? What follows from that may worry you, I suppose, if you thought that meant that it was had to be quashed, or the imprisonment, the detention was unlawful. Yes. But that's a different matter, isn't it?
Well, yes.
It could simply be a matter which required compensation. You could, for example, you could have a system where someone was perfectly lawfully in prison, but he was tortured. You get damages then rather than release.
Yes. But in my submission, the absence of, let's say, a sort of, it wouldn't be, in my submission, it wouldn't be enough. Certainly, one shouldn't transplant to Trinidad and Tobago this proposition, that because, let us say, Mr. Lendore didn't know at the outset, or wasn't told at the outset of his sentence, what he had to do in order to improve his chances of remission or being released, it follows that his sentence was cruel and unusual. In my submission, that cannot be right. It may be that a better prison system would make that plain to him, but it doesn't follow that because, as well, what you might call the factors that will be taken into account.
Well, the trouble is that, I mean, in convention terms, if you were in Strasbourg, they can only work with the tools of the convention, and Article 3 is the only peg they could hang this point on.
Yes.
So I suppose, but the fact, in a constitutional context, your point is that not everything is unconstitutional.
Yes, exactly, yes. And that's why so much is a matter for individual states. I mean, I submit what is going on in this judgment is a discussion of what is really desirable, but they're not prepared to say that it's necessarily cruel and unusual. Because if it was necessarily cruel and unusual, they would have to intervene. They couldn't say it's a matter for the local state to decide what to do if the local state's being allowed to do something which is cruel and unusual. My Lords, I think finally in this judgment, one goes to paragraph 126. Pick it up at 126. 126 explains why I think the solution found in Bieber wasn't good enough, and 127 is the conclusion. These are highly restrictive conditions, and so on. So it's another reference back to Kafkaris. So, my lords, I do submit it's very important when you read this case to bear in mind exactly what the issue was. A very restrictive law indeed. Now, there's no suggestion that applies in Trinidad. Indeed, it's entirely general. The one thing that can't be said is that it's restrictive, the system in Trinidad. And your 4 yearly reviews, which I respectfully submit, isn't bad. 25 years was one of the minimum recommendations, I think, which is referred to in Vinter. So I submit it's genuinely reducible in accordance with ECHR correspondence. My lords, finally, may I just go to the case of Harkin, which I think is at volume 9, on the second further supplementary authority bundle, tab 16. My lords, this is the extradition case from a request from Florida, which was considered by the Court of Appeal in 2014. And the problem was said to be that the provisions of the Florida courts were provided for no possibility of parole. Therefore, if you extradited the person who they wanted to extradite, he'd be subject to cruel and unusual punishment, and therefore shouldn't be extradited. And they talk about Trebelsi in paragraph 114. I think actually they begin their analysis of Trebelsi slightly earlier, forgive me. 112. They start the discussion of Trebelsi there. And in paragraph 116, they note what was noted as the central issue in Trebelsi, whether over and above the assurances provided, the provisions of the US legislation governing the possibilities for reduction of life sentences and presidential pardons fulfill the criteria which is laid down for assessing the reducibility of a life sentence in its conformity with Article 3 of the Convention. We note the terms of the question. First, the judgment of the court apparently contemplates that there must be some sufficiently precise legislation, as judged by the ECHR, in dealing with the topic. That would appear to go beyond what the court has previously said in leaving the form and content of any review mechanism to individual states, whether they are contracting states or not. And, my lords, obviously I adopt that gratefully. Secondly, given the way the second sentence of para 136 is phrased, the word its must refer back to the provisions of US legislation. Thus, the court appears to be saying that a relevant question is whether that legislation is itself in conformity with Article 3. If so, that's contrary to all previous statements of the ECHR concerning extradition in Article 3. Indeed, paragraph 119 in this case, that is, the exercise of assessing the situation in non-conventions requesting state does not involve making the convention an instrument governing the actions of states not parties to it, or requiring contracting states to impose standards on such states. In paragraph 137, the court sets out what it regards the legislation must provide. There has to be a review mechanism requiring the national authorities to ascertain on the basis of objective pre-established criteria of which the prisoner had precise cognizance at the time of the imposition of a life sentence, whether while serving his sentence the prisoner has changed and progressed to such an extent that continued detention can no longer be justified on legitimate penological grounds. That's my learned friend's case, and I say, well, that goes well beyond Vinter. 119, we find this passage difficult to square with what the General Grand Chamber had so carefully said in Vinter, para 120, that it was not for the ECHR to dictate either the form or the timing of any review mechanism. And then it goes on to say in Trabelsi, the court seems to have taken the opposite view. And it goes on effectively to criticise what is said. So it says Trabelsi has gone well beyond Vinter and indeed has misunderstood it in practice. You can see the conclusion at page 100, para 120 over the page. It doesn't advance things beyond Vinter when it comes to. It shouldn't be taken as that, as doing that. So my submission, even if one gets into this whole debate, it is appropriate, so to speak, to transplant to a certain extent ECHR law. I submit Trabelsi is no guide at all. Vinter is the case, if I can put it that way. It's a much more considered case than Trabelsi, and it's what you might call bang on point. It's not in an extradition context, and it's a very, very full judgment indeed. And it's to be preferred insofar as one gets into this whole debate. And when you look at it carefully, I submit it doesn't say anything more than Cathcaris and Wellington said. My Lords, I wasn't proposing to go to any other authorities. Those are my submissions.
Any other? Thank you very much indeed. Yes, I didn't ask Mr. Fitzgerald Jr. whether he wished to follow, but I will ask, and Mr. Fitzgerald Jr. can no doubt speak for himself if he does wish to, did wish to follow, but yes, Mr. Fitzgerald, how long are you likely to need?
Well, my Lord, maybe a bit of time. I would be grateful if I could at least make a start now.
Yes, of course.
Just
no, we've got 10 minutes.
Yes. While we're on the point of cruel and unusual, it's fresh in everybody's mind. Can I just make this point in reply, which is that the danger of reimposition, because the Court of Appeal has said there's nothing wrong with the 75-year sentences and the life sentences, it is whatever else is self-evident. And my respectful submission is that if this case were left with the situation that it's going to go back, whether it be to a court or to the President, with it being left as possible that all these offenders, and you have, on the basis of Court of Appeal judgments, sufficient information about them to know the wide differences. That's just there's no. We've got.
Sorry, yes, just if it's left on the basis that 75-year sentences are
okay. In other words, if it goes back on the supposition that for these offences, these offenders, the three before this court, could legitimately receive 75-year sentences, I say that would be cruel and unusual. And it'd be cruel and unusual because it would be evidence that the individual circumstances simply had not been considered.
Why is that so?
Because
you're positing that you're saying that it should not go back on the footing that the 75-year sentence could be served. But that's going to depend, isn't it, on the penological and other considerations relevant on a review.
Yes, my Lord, what I'm saying is if all three received the same, that would be self-evidently arbitrary.
Well, yes, but that doesn't matter if it goes back to the review committee and it is clear it is made clear what matters the review committee must consider. The fact that one conclusion that they may reach is that 75 years is okay, is not a reason, it's not something which in itself should concern us.
Well, my lord, the Court of Appeal, in the context of these cases, upheld 75 years, my lord, and said it was a legitimate sentence. I say that if you just only have to look at the way in which they're imposed, in this case, all given the same thing, to say it offends against the basic principle laid down in res, that you've got to have consideration to the individual offence and the individual offender. You could not have that regard and reach the same 75-year sentences in all those cases. It's self-evidently, there are two criteria that render a sentence not cruel and unusual in my respectful submission. The first is that there is serious consideration of the actual culpability of the individual offence, and the individual offender. You could not reach the conclusion in our respectful submission that 75 years in each case was legitimate on that basis. And my second submission is, in any event, at present, there is no mechanism whereby the decision maker, and it's no good pointing to reviews made by prison officers who aren't even agreed to by the commissioner, who doesn't even get to the advisory committee, which doesn't get to the national security measure. That's no assistance. Unless the decision maker is required to have a consideration at some point, we say not later than 25 years, of whether there are penological justifications for continued detention, then I do submit that is a transferable principle, and it's a universal principle. And my lord, just before I break, perhaps I could just so that's my bottom line on the 75 years and the life sentences. My lord,
what you say applies to the life sentences also.
Yeah, my lord, yes. Again, if the same conclusion were reached, if Norbert Williams and the other offenders were all subject to the same undifferentiated penalty with the system as it operates now, then I say that would be self-evidently cruel and unusual, because it would be disproportionate. It would fail to have regard to the need to differentiate between the different levels of culpability, and there would be no guarantee that need to have regard to the different levels of culpability.
Well, I can see that that a sentence which didn't do that might, on your submission, be criticised on the grounds that the imprisonment was too long, or the potential imprisonment was too long. But that's not the same question as whether it is cruel and unusual. I mean, the cruel and unusual is a description of a type of punishment. Now, it may well be that a court makes a mistake as to how long the sentence should be. That may lead on appeal or by way of review to the reduction of the sentence, but it doesn't follow, does it, without more, that it's cruel and unusual.
Well, if it's
just a wrongful sentence on some other ground.
Well, my lord, with great respect, there is authority to the contrary, and I've got. Can I have? That if it's grossly disproportionate, it is cruel and unusual. Weems in the United States, adopted by the Privy Council in Bowen Davis.
I can see that some sentence of imprisonment may be so long that they are cruel and unusual.
For the particular individual.
But it is, there are two issues, aren't there? One is the punishment imposed cruel and unusual? And the other is it higher than it should have been? And there may be an overlap, but they are different questions.
Yes, but if it's so grossly disproportionate, and I submit that it would be, for these cases, it would be cruel and unusual. And my lords, we have got a document there which deals with the applicability of the European Convention. Perhaps it'd be of assistance if the board saw that, because that includes all the relevant cases on. And perhaps just before I break, if I could just, my lord, I'm sorry, if I can just slightly park that point. I will try and revert to it, but just it does arise on the last. But also, the reason for preparing this document is in response to the questions that have been asked about what is the origin of the Bill of Rights part of the Trinidad Constitution, and what's the relevance of the European Convention and the Canadian Convention. What we've sought to do is to underline the relevant passages in each of those. And the court can see that one sees in Pratt and Morgan, they applied the Suring approach, and one can see that they cite the European Court's ruling in the penultimate paragraph on page 1, and then found it relevant that it was double the time the European Court of Human Rights considered would be an infringement of Article 3. That in Spence and Hughes, this is the judgment. So this is.
Why don't we take this away and
Yes.
read it over the adjournment?
Absolutely, my lord. Yes, yes.
You want us to read the whole document?
Well, I'd be grateful. Yes, and my lord, just on the question of disproportionality amounting to cruel and unusual,
Yes.
page 6,
Right.
where it cites Weems.
Shall we forward to resuming at 2 o'clock?